they're ordered to do. This is a check on what your progress you're making on it. So when your name's called for that, come up to the table to your right. If you missed a hearing in the past, you won't be called with this group, you'll get called with the next group of hearings. But for any reason, because I sometimes have people sit here all day, if you think you should have been called, didn't get called, you need to go check in with the clerk and make sure they know you're here. Otherwise, you'll just sit here. If we don't know you're here, we're not going to call you up for a hearing on your case. Call the reviews, please.
Ashley Atkins, Emily Amicon, Crystal Cooper, Jeannie Covelli, Danny Dodson, Andrea Ellis, Clarence Falk, and Ashley Huff.
Ashley Atkins. Ashley Atkins has paid her fine, so she hasn't done her community service, and she hasn't appeared, so the warrant issued for failure to appear. Emily Amicon, I'm showing, is appearing by Blue Jeans, case number 2285. So you have made a payment on your fines, you still owe some?
Yeah, I made a $70 payment.
Okay, today, I see that, it was registered today. Okay, so you still have balance to do, you can pay that or work it off. If you do community service, you get $50 a day credit for every day you do.
Oh yeah, I can probably pay it off with my next paycheck. I just got my place and stuff and I just have a baby, so it's just been kind of like hard to just pay it off completely.
I understand. Okay, yours is a newer case, so I'm going to give you more time before your next hearing.
Okay.
I'll set it for December the 18th. If you pay it off by then, you don't, or work it
Yeah, I
off,
can do that.
you don't have to show up for the hearing. December the 18th at 9 o'clock is your next hearing.
All right, awesome. Thank you very much.
Oh, okay. Are they in the courtroom?
Are they in the courtroom?
The folks from
Ohio State?
Nationwide Children's
Yes.
Hospital? Okay. There you are. Okay, you want to come? Let's, I'm going to let them come up, and I didn't realize they were here today. This is a research project that our court is cooperating with from Nationwide Children's Hospital in Columbus, and they're here. And I'll let them tell you what they're doing, and there's a possibility for you to make some money if you want to participate in it. And the other thing I'd say, it's all confidential. You'll meet with them here, give them some information. I mean, I may see the final results from all the data that comes in from the state, but I'm not going to say, oh, Joe Smith said this about me or said this about what his experience was. I don't give any of the individual information. It's all confidential. So go ahead and tell them what you're doing.
Good morning. Thank you so much for allowing us to kind of interrupt here. Good morning, everyone. My name is Zara, and this is Natalie. As Judge Capper mentioned, we're here from Nationwide Children's Hospital, and we are working on an overdose prevention study. We're working with different courts around the state to find people who might be interested in completing some surveys related to substance use as a way for us to test different strategies for reducing the risk of overdose. Anybody who is in this courtroom might be eligible, so you're more than welcome to just check in with us. We'll be in the room around the corner. It is voluntary, so you don't have to participate if you do not wish to. You may withdraw at any time. It is confidential, as Judge Capper mentioned. We don't work with law enforcement or with the court, so anything you share with us is completely confidential, and it is paid. If you choose to enroll today, you will get $25 for your first survey, and then the rest of it is fully remote, so you will get surveys sent to your phone or email. All of those are also paid start to finish. If you complete all the surveys in the study, it's about $360. It's very straightforward. If you just want to know more, you don't want to enroll yet, that's totally fine. You're more than welcome to meet with us. But thank you.
Thank you for being here. So where they're going to be on the other hall, the west hall that goes down that way toward where the holding cell is, there's a room back there that we call the attorney's room. When we were doing more in person and the prisoners were coming and back in the holding cell, the attorneys would use it to meet with their clients back there. So since most of the prisoners don't come now, they're on teleconference, that room is available. So you can go back there, you won't be put in the holding cell, you just go meet with them, you can leave at any time. And as they said, if you talk to them, it's like, I don't think that's something I want to do, fine, you don't have to do it. I don't know whether you do it or you don't do it, but here's what they're trying to do. They're collecting data from all around the state from people that have been involved with the court system and may have had and have had substance use issues. And the whole idea is to try to look at this data and come up with ways to reduce the overdose that are happening in our state. It's, last year was the highest overdose death rate in the United States ever. And that's, in my opinion, because of fentanyl. Fentanyl is extremely dangerous. It's out in our community. So we just want to get people's experience and try to look at, they do, I'm not doing it. They're going to look at your experience and from people all over the state and try to figure out ways to reduce the incidences of overdoses. There's some way we can do that by looking at the data. So you'd be just a small part of that and you get paid for doing it. If you don't want to do it, that's fine too. So anytime you get finished in the courtroom and want to go around that way, on the west side, just go down that hall. And if there's somebody who can't figure it out, prosecutor's office back there, just ask them to show you where to go to. So, okay, Crystal Cooper.
That's me.
22485. You did make a payment on your fines.
Yes.
And that's all you have to do is pay off your fines and court costs. So I'm going to set you for December. Does it matter if it's Mondays or Fridays?
Can we do like Fridays, because I go to the
Fridays are
doctor,
better?
yeah.
December
please.
the 15th, 9 o'clock. Once you paid it off, you quit coming to these hearings.
Okay,
Jeannie Cavelli,
Thank you.
324667. Can you make any payment on your fines today?
Yes, $100. I had COVID, so I missed some work.
Okay. I'll put you down for that.
Okay.
Yours is a newer case, so yours is going to be set sooner. So I'm going to make yours December 4th.
Okay.
It's your next hearing.
Yes, sir.
Get it paid off and you can quit coming.
Gotcha. Thank you, Judge Kaplan.
See the clerk.
Thank you.
Danny Dotson, 20223, 192448. And you've been at RRS, are you still there? Or
No,
what's-
I completed.
Yeah, Mr. Dawson completed.
Okay. I don't see a completion letter. Can you get me a completion letter?
Yes, sir. I'll
Mr.
send
Wynn?
that right now.
Thank you. Do you have a payment on your funds?
I'm gonna come back after work today. I don't get paid until later.
Okay.
I'll come back and pay on it.
How much are you gonna pay?
Probably 50.
Put you down, and you can be here before 4 o'clock?
Yeah.
December, and does it matter if it's Mondays or Fridays?
I prefer Fridays.
December 8th. That is a Friday. December 8th is your next hearing at 9 o'clock.
Thank you.
Andrea Ellis, 220774. You've got community service and funds and costs to pay.
I have a payment today, and I haven't had transportation, and it's been hard to have transportation and get back and forth to work to do the community service, but I worked it out with my boss this week that I can go on Saturday and possibly a few days next week.
Okay, so you're gonna be here tomorrow? Mm-hmm. Okay, Mr. Cooper's got you down for that.
Okay,
And you're making a payment today? Mm-hmm. How much?
20.
Okay, see the clerk, make your payment. And Mondays or Fridays better for you?
It doesn't matter.
Either one?
Yeah, I just gotta tell them a week in advance, so.
December 11th is your next hearing, 9 o'clock. Clarence Falk, it's been called 04578, is now, oh, you are here, Clarence Falk. You You just have fines to pay. And you've been working extra community service toward your fines.
Yeah, I've been working with Josh. I think I did 150 this month.
Yeah, I see you got 18 hours in, so that's good. You've done a lot of extra toward your fines. So keep that up. December 15th will be your next hearing. Get it finished and you don't have to come back. 9 o'clock, December 15th.
Thank you.
You're welcome. Ashley's office here, 2758, 2724, 2718. How are you, Ms. Huff?
Good, sir.
Can you make any payment on your phone?
Yes, sir.
How much?
$40.
Okay. See the clerk to make your payment, and I will set you for December the 18th. 9 o'clock, December 18th.
Jeremy Lewis, Cody Mead, Mark Oden, Richard Wright, Brian Stapleton, Alfreda Steele, Kimberly Thompson, Sarah Woods.
Jeremy Lewis.
Yes, sir.
222562 and 22674. You made a payment about a week ago, it looks like.
Yes, sir.
You still have community service to do.
How much community service time?
5 days.
Okay, yes, sir. I need some more time.
When can you start on that?
Anytime.
Tomorrow? No time like the present. Tomorrow.
Tomorrow? Sure.
Okay, Mr. Cooper's got you down tomorrow.
Okay.
Are you making a payment on your fines today? You made a payment the 13th, so that's fine.
Okay.
All right, next hearing, Mondays or Fridays? What's better?
Friday.
December 15th,
Thank you.
9 o'clock, December 15th, your next hearing. December 15th. Cody Mead.
Thank you, sir.
23-152.
Your Honor, if I may, Mr. Meade was ordered on 9/25 to be here on 10/7 for the cleanup, and he did not show up that day.
22-1690 and 22-2101. What say you, Mr. Mead?
Cleanup. What do you mean?
You was to be here on 10/7 to do community service on a Saturday.
I don't see that you've done any. Have
I don't think I have any. I ain't had community service in almost a year and a half, 2 years.
you? Okay. Order him placed in custody.
Come on, go back through here.
That's great.
Got anything else you want to say? I advise you not to. You might just add to it. Mark Oden, 22-185. 22-183. 22-182. 22-159. 21-901. You have done some extra community service since the last hearing toward your fines.
Yes, sir.
Do you have any payment today?
No, not today, sir, but I'll have it paid off before December.
Okay. Well, you did do something in the last time period toward your taking care of things, so that's good enough to keep you out of jail.
Yes, sir.
You can keep doing community service or you can pay it off, but all you have is fines and costs at this point. So,
Yes, sir.
Mondays, are you working now, or what's going on?
Yeah, I'm working, sir.
Mondays or Fridays, which is better for you?
Fridays is fine, sir.
December 15th is your next hearing
Sir.
at 9 o'clock. Once you finish this out, of course, you don't have to come back anymore unless you want to, for visiting.
No, sir. Thank you, sir.
You're welcome. December 15th is your next hearing.
Thank you.
Richard Wright.
Sir.
Approach, Your Honor.
Yes, 18-1347, 19-218. Thank you. Is that Lawrence County Recovery? It's a very good report, Mr. Wright. Thank you for that. And I'm showing you did some of your community service. I'm still showing 17 hours owed, that you did some community service since the last hearing.
Yes, sir. Your Honor, I've been busy at work all week. I tried to get my community service paper this morning before I came up here. That's why I was running a little bit late, but I wasn't able to because he didn't show up, so I had to come. They could call down there and verify that if need be, but.
You got some extra hours at the dog pound?
Yes, sir. Yes, sir.
Okay, we'll just get them in here and finish that up. I'm showing you it still owes 17 hours.
That's fine. I'll have it all completed.
And are you making any payment on your phone?
Yes, sir. I gotta go pick my check up, then I'll be back.
How much are you paying?
$40.
Mondays or Fridays, which is better for you?
Friday would be fine for me.
Okay, December 15th is your next.
Do you have, how much I owe left on my fines? Or will they tell me over there?
140 on one case and 385 on the other.
Okay.
But to get it really accurate, you probably need to go check in with Mr. Major,
Okay.
let him pull it up on the computer.
Okay. When did you say again?
December 15th.
I'll have that community service done by the time I come back up here.
Thank you.
Thank you.
Thank you for what you're doing in your recovery and taking care of it.
Thank you, buddy.
All right, Brian Stapleton. I'm gonna put this one aside. I think this is,
He also has the right to.
okay, we'll recall him because he's got something on the regular docket also. Your name, ma'am?
Kimberly Thompson.
Kimberly Thompson is 23-177. You just have to pay fines. Do you have a payment today?
Yes, I do.
How much are you paying?
I got 25. I just started working.
Okay, well, that's fine. And you can also, as you heard, you can do community service, you get $50 a day credit if you do community service. You weren't ordered any community service, but it'll go toward your fine if you
Okay.
want to work it. And your work schedule, what's better for you, what day's better for you?
Fridays.
Fridays? Okay, yours is a newer case. I'm gonna make you actually December 29th.
Okay.
Last Friday of December is your next hearing.
All right. Thank you.
You're welcome. Alfreda Steele, 13. She's on teleconference, 2828. All right, Ms. Steele, you did make a payment on October the 5th. You have community service still left to do too.
Yeah, the community service, my doctor has to clear me because I have COPD and emphysema. So he has to clear me before I can do any kind of community service up here.
Okay. Well, that's fine. If you're not cleared, you have a 17-day jail sentence that you'll have to do.
I know this.
Okay. So those are the options. You either got to do the community service, and we have light duty. If you think you can't do heavy duty, we can put you, probably work around the courthouse doing some cleaning. But you got to do it. You either got to do it or you got to do the jail time.
Right, yeah, I'll do it instead of jail.
Most people do. I've healed a lot of people that way. I would. I've never spent the night in that jail, but I visited there. It's not a place I would want to spend the night.
No, me either.
Okay.
3 days I was in there, I'm good with that.
I'll set your next hearing for December 1st. Yours is an older case, so we can get you back in here sooner. December 1st is your next hearing, 9 o'clock. Get your stuff done.
Okay. I will.
All right. Sarah Woods is also appearing by teleconference. 22-326, 21-686. And there's community service on both these cases that have got to be done. And you were at Bethesda. Are you still at Bethesda?
I am at Mended Reeds now.
Okay. When did that happen?
September 20th.
When? I didn't hear what you said.
September 20th.
Because I got a report September 15th from Bethesda. Are you appearing from Mended Reeds right now?
Yes.
Okay, so you're inpatient there?
Yes.
And I see somebody off to your right side. Okay, that's a very familiar face. So I take it that she is at Mended Reeds, because I know he works at Mended Reeds. So how's she doing?
Overall, Your Honor, she's doing very well. She's compliant. She just raised her level of care to 2.5. She did come to us after a surgery, so she was pretty much on bed rest and medical watch for a little while following the recovery of that surgery. But she's doing well. She's meeting her treatment requirements and is more or less bragging on by that.
Okay, and it's my understanding from a note I have in the file that you also have a case in Common Police Court. Is that right?
Yes, sir.
Is it still active, or are you on probation? What's going on with it?
I'm on probation.
Okay. Well, I feel like in that case, then I don't have to see you as often. I'll let them supervise you mostly. So I'm going to set your next hearing, and I'm assuming she's going to be at Mended Reeds for a while?
She should be, yes, Your Honor.
January 12th. Second Friday in January, I'll set your next hearing here at 9 a.m.
All right, sir. And I did quite a bit of community service with Bethesda. I wasn't sure if that would count towards.
Not usually.
Okay.
You have to get that approved in advance, and I don't think we usually approve community service done at the treatment facility where you're getting treatment. So.
Okay.
All right, January 12th will be your next hearing at 9 o'clock.
All right. Thank you so much.
Good luck. Take advantage of what you've got offered to you there.
Oh, I absolutely am.
Okay, that finishes up the reviews. Okay, the next hearings are what are called arraignment hearings, and the purpose of these hearings is for new cases, to tell you what the charges are. So if anybody's out in the lobby has got a new case, you need to come in court now. Arraignments, come in now. I agree, it's hot in here, so that's what you said. What was it set on, anyway?
You set on 73, Your Honor.
Yeah, too warm. Burning up. Okay, when your name is called, come up to the table to your right, stand there, and I'm going to go over the charges with you. And I'll tell you the possible penalties. If it's a misdemeanor, I'm going to ask you for a plea. Your plea is your answer you make to the charge. And you have three choices. You can plead not guilty, guilty, or no contest. The safest plea is always not guilty. That preserves all the rights you have, which I'm going to explain to you here in just a minute. Guilty or no contest waives your rights, and you shouldn't do that. One, if you don't understand what's happening. Two, if you want to talk to a lawyer. Three, if you want a trial on your case, if you want to contest the case, you need to enter a not guilty plea. I have people say, I just want to get it over with. I'm entering a guilty plea. That's not a good reason to enter a guilty plea. You have a right to remain silent. You don't have to say anything about your case under the Fifth Amendment. You have a right to remain silent. But if you do say things, And I have people do this, they get up and the first thing they say is like, yeah, I did it. Well, if you say that, that's going to be, can be used against you by the prosecutor. He has to prove their case. Admissions in the law are big deals. If you admit something, that can be used against you later. It's like, case over. You've already admitted you did it. It's hard to withdraw an admission. You have a right to have an attorney. You have a right to have one appointed for you if you can't afford one. You have a right to bail and to make the state prove any charge filed against you beyond a reasonable doubt. If you enter a guilty plea or no contest plea, you're waiving those rights. You should not do that if you don't understand or confused or want to talk to a lawyer. Enter a not guilty plea. Call the first case.
State of Ohio versus Glenn Lett Jr., case number TRC 06-1081. Glenn Lett Jr.
All right, sir, you're Glenn Lett Jr.?
Yes, sir, I am.
All right, Mr. Lett, it's alleged that you missed a review hearing back in July of 2019, and a warrant was issued on that failure to appear. This is on an OVI charge, 06-1081. And
Yes,
that looks like you got arrested on the warrant and have posted a bond since then. Is that correct?
Yes, sir.
How do you wish to proceed? Do you want a law, are you going to contest this? Do you want a lawyer? How do you want to proceed with it? This is just on the failure to appear. You already were sentenced on the OVI charge.
All right. What all do I have to do? Like, I don't.
You admit or deny that you missed the hearing and that you had no just
I
cause?
admit that I missed the hearing, yes.
Okay. You had an explanation for missing?
I was an addict.
Okay.
I'm recently now 3 years sober. Went through long-term treatment facility.
Where'd you do that?
In Grayson, Genesis, in Kentucky.
At the time, it looks like you were a West Virginia resident, but at the time you had this OVI, is that right?
Yeah.
Now you live in Kentucky?
Yes, sir.
Okay.
Yes, sir.
Well, here's the way this works. I'm just going to find you in contempt for not coming to your hearing before I'll sentence you to this time you served now before you post the bond. You got taken to jail and had to post a bond. So
yes, sir.
That's some punishment of itself. So what we'll do, I'll reschedule you for review hearings, and you will come back periodically until you get this stuff done. What I'm showing that you owe is 30 hours community service, $1,113. Well, it might be even if you paid anything. Yeah, you did pay some stuff. You paid, maybe you paid the whole fine off. You paid a payment here recently. That probably hasn't been adjusted yet. So you may have paid everything off.
That was for the cash bond.
Oh, just for the bond, okay.
Yeah, I think I owe like 900 and something, I think it is, or
You
something.
owe $1,083.50.
Okay, I can pay 50 on it today.
Okay. All right, so what we'll do, I'll set it up for review hearings, which you'll keep coming back until you finish everything.
The 30 hours community service, so I have a full-time job. I live in Kentucky. Is there any way that we
Where
can...
do you live in Kentucky?
In Grayson. Is there any way that we could set some kind of community service up there that I could possibly do like in the morning times?
You can do it in your home area.
Okay.
You can either do it at the court there. I haven't worked with that court. I don't know if they have a community service program, or you can do it at a legitimate charitable organization.
Well, if I go and say I donate some time to Genesis, my recovery center.
No.
No.
I want you to do it for the Red Cross, Salvation Army, something like that. I don't want you to have a prior relationship with the organization.
Okay, I'll figure something out.
You can talk, Mr. Cooper here that's in the courtroom is in charge of community service.
Yes, sir.
You can always come here any day at 7:30 except Sundays.
It's just so hard to get from there to, I gotta be at work at 3 o'clock.
You can go Grayson, you're pretty close to, Portsmouth then? You can go to Portsmouth Municipal Court, you can go to Arraignment Municipal Court.
Well, we gotta also think, Judge, I ain't got a license.
Oh, okay.
So, like,
It's hard too.
and I just paid $4,000 in West Virginia to get my license, but they didn't inform me that I paid the reinstatement fee for the DUI that I'm in here on right now in West Virginia, and they told me everything was cool. Like, I had no worries over here or nothing else. Everything was clear. My license was clear. Like, all I had to do was take a
Well, with West
course.
Virginia, I guess, but not with Ohio.
Yeah, like, this is all new to me.
Well, and here's newsflash. Sometimes people make mistakes, including the B&B. They should not have told you that because your suspension's still active in Ohio, so they should still be honoring it in West Virginia. So.
Right.
But, as I said, sometimes they make mistakes. Okay, so what I'll do, I'll set this out. Since you're working, you'll have to come back on a Monday or Friday. Which is better for you on your work schedule?
Either or, Judge. It really don't matter.
I'll set it for December 29th.
Okay.
So that gives you a couple months to get, if you can get it done in a couple months, fine, you don't even have to come back.
Okay.
I just want you to finish up. So you've got to pay your fines, do your community service, and look at the entry, but you probably have to go to the driver intervention program.
On that intervention, I was told to ask you, so I spent 72 hours back when I got arrested on the failure to appear. Would you care to take that under consideration and let me, because I just lost $100 putting towards this class that ain't going to matter for nothing now.
Oh, in West Virginia?
In Kentucky, yeah.
Oh, Kentucky. Yeah, you got to go to an Ohio-approved program.
Yeah, but I was told that you might be able to accept that I done the 72 hours in jail before.
Where did you do that?
In Lawrence County.
This time?
No, the last time.
Prior to the judgment entry?
Yeah, I stayed from Friday, I think it was Thursday night I went in, Friday all the way to
Well, here's
the
what you
next
have to
court
do
hearing.
now, because the judgment entry came after that. I know you're not a lawyer. So you either hire a lawyer and they can file a motion with the court to modify the judgment entry, or research it yourself, but you got to furnish proof to me, and I don't know if the jail's going to have records of that or not that far back.
Okay.
But get me some proof and then I would consider it.
Yes, thank you so much.
Okay. Okay, December 29th is going to be your next hearing at 9 a.m.
Yes, sir.
Okay.
State of Ohio versus Paul Cron, case number CRA 23644 A and B, CRB 23643, and CRA 22819.
Paul Crum.
And you are Paul Cron?
Yes, sir.
Mr. Cron, it's alleged in case number 644A that on October the 16th of this year in Fayette Township, you not only obtained, possessed, or used a controlled substance having in it a fentanyl-related compound. So possession of a fentanyl-related compound is a particular statute now, which is a felony 5. That means it carries a maximum penalty of a year in jail and $2,500 fine. You're also charged in 644B that on October the 16th in Fayette Township, you were in possession of methamphetamine as a Schedule II substance. That's also a felony 5. Maximum penalty is a year in jail, $2,500 fine. 23643 alleges October 16th in Fayette Township, you were in possession of buprenorphine, which is a controlled substance, a Schedule III substance, possession of which is a misdemeanor. Maximum penalty 6 months in jail, $1,000 fine. Those are the new charges. Do you understand those new charges?
Yes, sir.
Then you got some old charges. 22819 was a littering charge. And it's alleged that you failed to appear for a review hearing on September the 15th of this year and had a warrant issued because of it. So do you understand the charges that are pending against you? Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
No.
No income?
No.
Is Mr. Stratton, is he on the docket today?
No, sir.
All right. Mr. Scott?
Morning, Judge.
Good morning. Mr. Scott, this is Paul Cron. He's got a couple of new cases that are, the most serious ones are F5 possession charges. He's got an old case of littering that he failed to appear for a review hearing on. He did show up today, and apparently was, I don't think you posted a bond. Were you just cited in the court, sir? Or?
Yeah.
Okay. So I'll let you sign a signature bond because you showed up on your own. I'm going to make it a $5,000 signature bond. As long as you show up, you don't have to post the money. If you fail to show up, you get a warrant, and then you got to post $5,000. So when would you like to come back for the preliminary hearing? And I don't know, usually the state would like to see treatment. I don't know. As a condition of bond.
Judge, let me grab my schedule real quick.
You have Mr. Hill come in?
Sure. Judge, I'm thinking 30 days. I'm going to highly encourage my client to get in treatment of some sort that would give us time to get some sort of report back.
Okay. It's Paul Cron, so he's got 2 possession charges, 3 possession charges. One is buprenorphine treatment. What's the status?
All those people back there are all treatment providers.
If Mr. Cron is willing to do what's being suggested, and that is to take into an assessment and treatment,
Ohio, Medicaid, I think.
At this point, we probably would be able to agree to leave the case here, dispose of it here, if he's successful in his treatment.
How do you pay for medical services, Mr. Cron?
I got a medical card.
Ohio?
Yeah. So we're just talking about, Judge, there's the slew of providers in the back of the courtroom, and he has a couple of resources he's going to reach out to.
Well, why don't we do that? I'd like to know what he's doing before he leaves, especially if we're going to continue for a month.
Sure.
So let's have him meet with some of the providers, come up with a plan, come back in here, and decide, we'll finalize terms of bail after that happens. So
sounds good, Judge.
All right. We'll recall Mr. Cron later in the docket.
If all that goes as we are suggesting, we'll need a time waiver too, Mr. Scott. So
Absolutely.
Go ahead and fill one of those out.
The case will be recalled.
Good talking with those to get something figured out today.
State of Ohio versus Stephen Easterling, case number PRC 21-998 A, B, and C, PRC 20-2581 A and B.
All right, Stephen Eastern is here. Looks like it's on you had a review hearing a week ago, right? Or Friday?
Yes.
Or, I'm sorry, Monday, I'll get it right eventually. It was Monday, the 23rd. I did get a text today from Amanda Rayburn from the VA, said you've been there, you've got some things scheduled with them.
Yes, sir.
So I encourage you to stay involved with them. They've got an excellent facility there that can help you.
Okay.
They've got a lot of resources they can bring to the table to help you with issues. So I will not issue a warrant since you came in. One had not been issued yet. So I'll cancel warrant. And I'm going to set you for another hearing. Was there you have an explanation why you missed Monday?
I just moved back to town from Columbus Wednesday.
Okay. Where are you going to be staying now?
With my grandmother.
What's the address there?
409 Maple Avenue, that's Ironton.
What's her name?
Cindy, Stacy.
Stacy is the last name? Stacey?
CY.
CY. Okay. Do you prefer a Monday or Friday? Does it matter to you when you come back?
Friday is better.
I'll make it December 8th. next hearing is December 8th. I'm making a note that you're at the VA now at Spring Valley. Okay. So take advantage of what they have for you there, and they work with the court very closely, so they will give me a report. Okay, thank you. Good luck.
State of Ohio versus Jonathan Carr, case number CRB 16926.
Right, Jonathan Carr and Mr. Carr, it looks like the record shows you missed a hearing back in June 6th of 2022 on a review, and work's been outstanding for over a year on that, and then you're coming in today.
Yes, sir, Your Honor.
Do you have an explanation as to why you missed that hearing?
Yes, sir, Your Honor. I was in active addiction at the time and I was struggling. However, I did go to prison on a parole violation in March. I got out June 5th and went to Franklin County CBCF, which I graduated and have a certificate for. I went from that to Sunrise Treatment Center in my hometown, Sauter County, and graduated that, and now I'm in transitional living. I have multiple certificates.
All right, very good.
Would you like to see these too? Thank you.
Okay, you just completed the Sunrise.
Yeah, I moved from there, so I'm in transitional now.
Inside of the county?
Yes, sir.
All right, well, I applaud. Looks like you're on the right track now.
Yes, sir, Your Honor.
You still have some community service and fines and costs to do here. When I work with you, you can work off your community service. You don't have to pay it, so I'm sure. I mean, do you have a job yet, or?
I'm looking for employment right now,
Okay.
but I heard you say something about the Portsmouth Municipal Court. I could work with them to get my...
You can do your community service there.
Okay, great.
And just make sure they send us the hours.
Yes, sir.
You do there. Okay, I'll set this for December 15th as your next hearing. So that gives you some time to get things going. Congratulations on your sobriety. Keep working at it.
Thank you, Your Honor.
I want to encourage you in that, and I'll work with you. As long as you're making that kind of effort, then I'm going to work with you. And I know you don't have a lot of money laying around to pay fines, but we'll work that out as long as you keep making an effort. Keep working at your sobriety.
Okay, great.
Okay. December 15th, and actually, if you're in compliance and doing things, I'll let you appear by teleconference.
Okay,
If
great.
you got a smartphone or a laptop, you can appear by teleconference. Just check in with probation, they'll give you the sign.
Okay. Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio versus Brian K. Stapleton, case number CRB 23593, CRB 22573, CRD 23983, A and B. Brian Stapleton did not check in, Your Honor.
Okay, this is Mr. Morford's representing him on some old cases. Is Mr. Morford here yet?
Yes, Your Honor.
Good morning, Mr. Morford.
Good morning, Your Honor.
You had represented a Brian Stapleton, and he has a new charge. He had a review hearing today too, so you probably, I'm going to assume, don't have any idea where he is or have heard from him.
I don't judge. No.
Okay. He's failed to appear. He was served by personal service of the summons. So I'm going to go ahead and issue a warrant since he failed to appear today.
Judge, do you have the date that he was served there?
October the 4th.
Okay. I will try to reach him with whatever contact information I have, Your Honor.
Okay, thank you.
You're welcome.
The warrant issued for failure to appear.
Thank you, Your Honor.
Also, but because he had a review hearing scheduled for today too, so on both the new case and his reviews, he gets a warrant.
Thank you, Judge.
You are. Okay, that finishes the arraignments we have. We're probably going to have some more as they get paperwork ready. And I know there's some from the jail that we'll be doing. We'll go back to. We're going to start some of the pre-trials now, so anyone that's out in the lobby has a pre-trial. We need lawyers to come in for their pre-trials and the prosecutor.
State of Ohio versus Brian Smith, case number TRC 231421, A and B.
Brian Smith is Mr. Green's case set for pre-trial.
Your Honor, we just received discovery, I believe it was yesterday in this matter, that we could reset this maybe to the 20th day of November.
You say 20th?
Yes, Your Honor.
Yeah, that's fine. All right, this is Brian Smith. They're asking for a continuance to November 20th, which is a good date for the court, so I'll continue this for another pre-trial, November 20th, at 10 o'clock.
Thank you, Your Honor.
State of Ohio versus Cameron Spitzer, case number TRC 231161, A and B.
Yes.
This is Mr. Kermeen's case also set for pre-trial.
Well, likewise, Your Honor, we just received discovery in this. We can continue this the
Same date, November 20th. Sentence request, case is continued to November 20th for a pre-trial, 10 o'clock.
State of Ohio versus Sean Woods, case number TRC 23811, A, B, C, and D.
That's fine.
This is Mr. Kermeen's case set for pre-trial.
Your Honor, Mr. Bill and I discussed this case at length, and we have been working towards a potential resolution in this matter. I've spoken with Mr. Woods about that resolution this morning, and he wanted a little more time to talk to me in depth about it. If we could come back another day, I mean, 20th day of November, I don't know if it still works.
Okay. If the defendant's request, case is continued to November 20th for another pre-trial.
State of Ohio versus Deshaun J. Hanna, case number CRB 23565, A and B. Deshaun Hanna. Deshaun Hanna.
This is Mr. Scott's case, I believe.
Yes. Deshaun Hanna.
Your Honor, this is a case that I spoke with Mr. Scott about this morning, who's either here or was here. There's Mr. Hanna. What I tried to do was, there's a companion case to this involving another individual who we've alleged owns the dog that was involved in this, but her case is set for Monday. And our feeling is that a proper resolution of this is going to involve her, maybe even more so than Mr. Hanna. And I wish that we hadn't had a situation where maybe he had to miss work this morning, but we'd like to move his case to Monday, but we also know that he works. And so having him here today is, we would be okay if Mr. Scott showed up on his behalf tomorrow, or Monday, and Ms. Scott, what's her name?
Webb.
Webb,
if
she's here, I think we can come to a resolution about this case, maybe. So continue this to the 30th and allow Mr. Hanna to be available by phone or teleconference for that hearing?
That should be fine, Judge. I apologize, I was outside with a different client getting set up with the treatment. I'm fully amenable with that, Your Honor. I'm sure he can be available by phone on Monday morning.
October 30th will be the next hearing, pre-trial, 10 o'clock.
Thanks, Judge.
You're welcome.
State of Ohio versus Charles H. Dennison, Case number CRB 23566, A, B, C, and D.
Good morning, Your Honor. Good morning. This is Mr. Nash's case for pre-trial today.
Correct. Judge, can we approach?
Yes. That's good. Seems like his last hearing. I just didn't think there should be a gun in the household where he was under the circumstances. I didn't make any notes of it, but I do remember, I think I said something about the chicken. Pretty sure he was. Well, I knew, because this is like I think it's a good idea to not make things now. That's all I think his parents are treatable. Real well, I know a little bit about him. I think it's an appropriate place for him. Just, yeah, several suicides here alone. This is kind of This is set for a pretrial today. It's my understanding we're going to be looking for another pretrial date in about a month. But in the intervening time, I think at the prior hearing I had made an order from the bench that there not be weapons in the household where he's residing. It's my understanding now he's living with his parents.
Are you living with your parents?
My parents, but my sister would have a gun at her house, and I don't go there. My sister,
Are you living with your parents?
my parents in Proctorville. I have the gun in my sister's house locked up, and I don't go there. Chesapeake.
Okay. Your Honor, Mr. Dennison indicates that he's living with his parents, but he's asking that the gun be released to his sister who lives in Chesapeake at a separate residence.
Where is the gun now?
I believe it's with the Sheriff's Department.
Okay. What's the state's position on that?
Well, Your Honor, the reason that the gun was confiscated was not because Mr. Dennison attempted to use it against anybody else. So this is probably a situation where even if he's found guilty of that offense, depending on a lot of factors, but it's not one that we would necessarily have to feel that we needed to ask for forfeiture of the gun. However, given the circumstances, I think it's better safe than sorry. We just leave the gun where it is for now and discuss returning it at a later date.
I agree with Mr. Heald on that. Obviously, it belongs to Mr. Dennison. We'll, down the road, take up where it should be, but I think just to be safe at this point, it's in a safe place. Let's just leave it there for now, and we can address that again later. I don't see any urgency to return it to his sister to hold. It can remain at the sheriff's office for now.
Thank you, Judge.
And we'll take that up later. So I'm looking for a date, probably maybe the last week of November, 1st of December. What's your schedule, Mr. Nash?
We have court here on Wednesdays and Fridays, is that it?
Mondays and Fridays.
Mondays and Fridays. I am available on Monday, the 27th.
That's a good day.
Okay.
All right. So exactly 1 month. November 27th will be the next pretrial at 10 o'clock. And at that time, we're going to discuss whether the case can be resolved or whether we'll be doing a trial on this and how that would happen. Okay.
Thank you, Judge.
November 27th, 10 o'clock is the next time.
State of Ohio versus Charles Hutchinson, case number CRB 21584, TRC 192635 A and B, TRC 181210 A and B. Charles Hutchinson, Mr. Morford's case.
You need Mr. Morford in the courtroom?
May I approach, Your Honor?
Yes. Okay, it's a bad report. He's had 2 failed screens for fentanyl recently, has missed appointments for his counseling sessions, and obviously he's not here today. Somebody issue a warrant for Mr. Hutchinson.
Thank you, Your Honor.
Thank you, Judge.
He's in danger. Charles Hutchinson, I've known him for a long time. He is a person in grave danger.
State of Ohio versus Dennis Cook, case number CRA 23637, TRD 164177, TRC 143645 A, B, and C, and TRC 143122 A and B. Did not check in, Your Honor.
Dennis Cook.
Judge.
Morford's case.
Your Honor, have you had an opportunity to speak with Officer Major?
I have not.
He received a phone call from the jail at 3 o'clock this morning. Mr. Cook was involved in some kind of altercation at the jail. Yes, Your Honor. And he is currently in St. Mary's in Huntington. They took him from the jail to the St. Mary's in Ironton, been transferred into Huntington.
Okay.
I've got a little more on this. This is Mr. Cook.
Yes.
3 o'clock this morning, I received a phone call from Deputy Sisler Mr. Cook got in an altercation in jail, had significant facial injuries, broken bones, and the doctor was admitting him to the hospital in St. Mary's. So I went ahead and released him. Speaking to another deputy, it doesn't seem like the doctor was really concerned whether we released him or not. He was going to send him.
Okay. It's a possession charge, so it's a felony. I think to ensure that we get him back, I should just go ahead and issue a warrant on him today, and then if he gets out of the hospital, then there'll be a warrant, and that would be good in West Virginia. So there'll be a warrant issued on all of his cases for failure to appear.
Thank you, Judge.
You're welcome.
State of Ohio versus Jade Lewis, case number CRA 23-432 A and B, CRB 23-433 A and B.
Mr. Morgan's case. I have Ms. Lewis at ODP.
Your Honor, she has been in our outpatient services. However, looking at her encounters yesterday, it appears that she has been discharged from outpatient for non-compliance and not showing up to her appointments.
I was sick and I made my appointment today.
Well, let's,
I have an appointment on the 6th.
she wants to stay out on an OR bond. I'm going to request that she submit to a urine screen so we know what we're dealing with.
Sorry. I had the flu and then I got exposed to COVID. So I
want her to do urine screen.
Do what the judges were in.
We'll recall her after she does the urine screen.
Go, that man knows takes care of it.
State of Ohio versus John McCoy, case number CRB 2697, CRA 233971 A and B, and CRB 22426.
May I approach, Your Honor?
Yes. McCoy's what it does to her. It's a good report, says he's compliant. Leading by example, doesn't get much better than that. Report. How you want to proceed? He's got a newer case and got an old case. He's been in treatment for a little while, but doesn't look like he's at a point where he'd be finished yet.
I would agree with that, Judge, and I think Mr. McCoy would tell you he's wanting to continue.
Oh, yeah, for sure.
Okay. Well, so far so good. Looks like you're doing well. Congratulations. And thanks for doing that.
Told you I would.
Well, a lot of people tell me things that they don't do, so I've become kind of cynical and skeptical in my old age, so.
He needs written proof.
Okay, so I applaud you though, you got a really good start, but this is a start. You got to keep working at this and.
Just stay tuned.
Develop a lot, this is going to be your lifestyle from now on, not going back the other direction. So that's what we got to see happen. And the longer you're in recovery, the odds of you staying in recovery go up. The longer your brain is clear and free, the better the chances are you're going to stay free and clear of substances. So let's get time in recovery is important. December 15th.
That's good here, Your Honor.
So you've demonstrated some good work, so I'm giving you more time before you have to come back. Keep at it. It's not over. December 15th, the next hearing on all these cases, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Heather Nessel Road. Case number CRA 23639 A and B, CRB 23640.
Mr. Morford's case, preliminary hearing and pretrial today. First one.
May I approach, Your Honor?
Yes. Okay. You're just getting started. You got a good start, it looks like. Your report says you're compliant. I think there may be, is this a case that the state's made a decision on whether it would take on the injury or leave here? What, the state have a position on that?
Well, she has a case in common pleas court in which she pled guilty on similar type charges and was placed on intervention in lieu of conviction on the 18th of October, and then she got this case on the 20th.
Okay.
So I
That's
think
not good.
it is, and the common pleas court, I believe, knows about that already and understands that she's at Bethesda with the GPS, which I believe she's on the monitor too. So in light of the fact that we plan on going that way, maybe today's a good day to go ahead and have her waive and have the case go to the common police court and accompany the one that's there already.
And she's involved with QRT apparently,
She was discharged
because of these charges.
because she left Bethesda, and then she wouldn't answer the phone or return my calls. I couldn't get in touch with her, I couldn't find her. So we discharged her.
Now, is she back at Bethesda now, or?
That's correct, Your Honor.
Okay, when did she come back?
The 18th? Yes, the 18th of October.
Okay. So that's apparently when all this, before this, and or this time frame is when this new charge arose. Okay. How do you want to proceed, Mr. Morford?
Judge, I will take Mr. Hills up on the suggestion to waive preliminary hearing so we can maintain the bond and allow her to remain in treatment.
Okay. All right, so is it pronounced Nessel Road, Nessel Rod?
Nessel Road.
Road. All right, Miss Nessel Road, I mean, this is a little bit complicated, but I want to make sure you understand the proceedings and what is happening here.
Okay.
You've already got a case in common pleas court. You're
Correct.
aware of that? So
Yes.
that's the court in Ironton.
Mm-hmm.
That's where felonies go for trial or further proceedings. So you've already got a case there. I'm understanding it's similar to these. So that means you've been indicted by the grand jury.
Correct.
That's an old remnant of English law, that felonies were considered so serious that your fellow citizens had to say, they had to look at the evidence that the state or the king or the queen had and say, yeah, there's enough evidence to go forward with this case. That's what an indictment is. So you've already been indicted on one of these cases. Now you've got these new charges. So the state's going to take it up. You're going to go to the common police court. And we had this hiccup in between, apparently, at least the allegation is that you relapsed, got new charges, but you have gone back to treatment. I assume you did that on your own, or did you do that after you got arrested?
I did it after I got arrested.
Okay.
But I did ask to go back.
Okay, well, here's the bottom line. Your case is now, you're not going to stay here. You're going to go on to the common police court. And that's what your attorney is recommending. He's saying, we agree, we're going to waive a probable cause hearing and just agree that these charges can go on to the grand jury for indictment, and you're going to be in front of the common police court.
Okay.
So you can't stay here. You're not going to get rid of your felonies by going to treatment in this court. One thing I want you to understand, the best thing you can do is stay in treatment. And you can't, on a felony, you can go to prison. You understand that? That's what a felony means.
Yes, sir.
It used to mean all felonies hundreds of years ago were potentially death felonies. Not anymore, but it does mean you can go to prison, not the county jail. Misdemeanors are county jail only, felonies, prison. The state of Ohio and everyone is looking for reasons not to send people to prison because they're full. And they're full of people that have had drug issues. So if you give them a good reason not to send you by showing compliance with treatment, showing that you're going to get in recovery, you're going to stay there, you're serious about this, that's the best chance you're going to have of avoiding going to prison. You don't want to go to prison.
No, I don't.
So you have to take this serious. You can't cut and run anymore.
No, I'm not.
That's
I'm staying
over.
put.
That's done.
Yeah, I'm staying put.
Unless you want to stamp it, say, send me to prison,
No.
then go ahead and take off. And, you know, some boyfriend calls you or says there's a party and whatever, I want you to show up.
I'm done
Go
with
ahead
party
and go to it.
days.
Then eventually you're going to wind up going to prison.
Yeah.
Is it worth it?
No.
It is not. Use your brain. Use your brain that's now a little bit clearer, and it will get clearer the more you stay in recovery. Make good decisions. Don't talk to people that are talking you into bad decisions. Okay?
Yes.
So that's your sermon for today. You're waiving your preliminary hearing. Your case is going to go to the grand jury, but stay in treatment and get good reports in treatment. Okay?
Your Honor, on case 23-640, you want that knowledge to the grand jury?
That'll be that's the misdemeanor. It'll be knowledge to the grand jury.
Thank
It grew out of the same set of facts. Okay, good luck to you, ma'am.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio versus Evan Harmon, case number CRA 23457.
It's Mr. Scott's case at the preliminary hearing.
That's correct, Judge. Mr. Harmon has, since we were last here, a couple months ago, he successfully completed OVP. I'm looking at a certificate right now. Looks like he had an outstanding patient board
Yes.
more than once, so he's done really well.
Thank you. Okay, what's going on with him? I see he completed the 30-day program. What's going on with him now?
I believe right now he is in transitional living, Your Honor.
Well, no, I'm living with my father.
Father, okay.
Yeah,
But you're doing outpatient.
outpatient
Okay.
with OVP. Yes.
Yeah, I just went this
Where are you going for your outpatient?
20th Street and 6th Avenue OVP.
Yeah, okay. And you're living in Huntington now?
Yes, sir.
At that Hughes Street address or someplace else?
Yeah, 4318 East Street.
Okay. Stay agreeable with keeping it here then?
Yes, Your Honor.
Okay, so the stuff I just told that last person,
Yes,
you're in a better position than she is. She messed up once and now she's going on down to the common pleas felony court. You're not, you're still in this court and the state's agreeable to keeping your case here, so you're not going to go to the grand jury. You're not going to get indicted if you keep doing what you're doing. You can get your case ultimately probably dismissed with no hint of a felony, no risk of going to prison. That's the best possible circumstance.
Yes, sir.
And you're on track to do that, but you got to keep doing what you're doing. No relapses, no blowing things off, no hanging out with the wrong people.
Yeah.
Okay, you agree with that?
Yes, sir.
Okay. Another month or so?
30 days, Judge.
November 27th?
Yes, let's do that.
All right, next hearing, November 27th. Preliminary hearing, 10 o'clock. Good start, Mr. Harmon. Keep it up.
Thank you.
Thank you, Your Honor.
You're welcome.
Mr. Scott, are you ready to recall Paul Cron?
Yes. Hang out, let me talk to you. Don't leave just yet.
State of Ohio recalls Paul Cron, case number CRA 23644 A and B, CRB 23643, CRA 22819.
Judge, it's my understanding that Mr. Cron was assessed by Shawnee. They've agreed to make him 2-day So if the court would allow that, he'll be transferred immediately after this.
Is that correct?
Yep, that is correct, Your Honor.
And you're agreeable to going there?
Yes, sir.
Okay, back up. So there's a thread through here.
Yeah.
You have felonies. The state at least hasn't said at this point I don't know, can you commit to keeping it here if he's successful, or what's your position on that?
They're F5 still.
Yeah, the only reason that we would go against our initial feelings on this and leave it here would be if we find out that there is either some other case pending in a higher court somewhere or something criminally that would keep us from, this record or whatever, but I don't see anything right now, so.
Okay. So what I said to the previous gentleman applies to you and also the lady before that. You have an opportunity to keep it in the misdemeanor court. Do well, you can get your case dismissed, not be indicted, not have even a whiff of a felony about you, which is really important. No risk of going to prison. Mess up, you're going to go on down to the common police court, get indicted, and then at least there's a chance you can go to prison then. Right now, there's no chance you go to prison. Just do what you're supposed to do. You understand that?
Yes, sir.
You're on board with it?
Yes, sir.
Okay. So, I'll order him to go to treatment with Shawnee. Are you back here? I'd like to come back before the 27th at some point, Mr. Scott. Do you have any other hearing dates?
Got a couple of jury trials in November. I can do the 17th.
That's a jury trial here.
Ah.
We're trying to keep that light because we're going to have a jury trial here.
I mean, the 24th, but that's pretty close to Thanksgiving.
Yeah, that actually is a holiday.
Other than that, 27th is the first one I'm available, Judge.
Okay, we'll do the 27th, and what I would ask Shawnee then, if there's a problem, you need to notify the court so we can bring him back in sooner.
Yes, Your Honor.
But at this point, November 27th will be the next hearing.
Now, Your Honor, is this Shawnee Mental Health?
Counseling Center.
It's
Shawnee
in
Counseling Center.
Okay, different than Shawnee Mental Health. I guess I wasn't familiar with this one.
It's newer to this court. We have some other people there before them. All right, November 27th will be the next hearing at 10 o'clock, preliminary hearing.
Thanks, Judge.
You're welcome.
Thank you,
Good
Your
luck,
Honor.
Mr. Cron.
State of Ohio versus Jessica Johnson, case number CRA 22-156, CRA 22-157, CRA 22-545.
It's Mr. Smith's case.
Yes, Judge.
Mr. Morford, one of your clients has showed up. Mr. Hutchison. Thank you, Judge.
Okay. That's good.
Yeah, Approach Judge, I have a
Yes.
report from Valley Health.
Okay, it's a good report, much better than the last time. So, continue on, she's in treatment with Valley Health.
Yes, sir.
December sometime?
The 1st, 4th, 18th, or 15th.
18th. Next hearing is December 18th. Continue with your sessions at Valley Hall.
Yes, sir.
State of Ohio versus Jason Turner, case number CRA 23638. Jason Turner.
I think he's in jail.
I think he's behind you.
No.
Or is this Jason?
I don't know that Trace, you were one of the other members. Okay, I recall this one now, okay, you're at Riverside. Yeah, he had
Right,
transportation.
RRS.
He had transportation issues, which was causing trouble getting to Bethesda. We were asking Monday if he could go to RRS, and it looks like we have a report from RRS.
Well, in light of his drug screen, should he be moved up to, I mean, he was,
Your Honor, this was his initial drug screen when he came in on Wednesday. So we're monitoring it closely, and I've explained to him that any more failed screens, especially for fentanyl, will result in inpatient treatment.
do you understand that, Mr. Turner?
Yes, sir.
Well, in light of that, I think we need to come back sooner. Give me the dates when you're available.
I have some November dates or December dates.
Let's look at it, let's look at November.
I have the 20th or 27th. And December 1st. If I have anything else sooner in November.
The 20th is the earliest.
I'm double checking, Judge. I could do Friday, the 3rd of November, if I could get here at 11 o'clock, if that'd be
That'd be fine. Let's do that.
Okay.
Next hearing will be November 3rd. 10 o'clock. Okay, let's get a good report then. Mr. Turner.
Yes, sir.
Thank you, Your Honor.
Okay, we're going to the jail now. You're up for some hearings.
State of Ohio versus Justin Carter at Lawrence County Jail, case number CRA 23634A and B. Tracy Dement is on deck.
Recording has started.
This is the Morgan's case.
Justin Carter is also Mr. Morford's case. Set for preliminary hearing.
Justin Carter, did you have a chance to talk to Carl? Did you have a chance to talk to Carl about this? He's got a common pleas case. No, I didn't get a chance to ask you because they called me out here.
How do you want to proceed?
Judge, that's what Mr. Hill and I are just discussing now. He has a holder for common pleas. I don't represent him there, but I understand the hearing on that is November 18th, I believe.
November 8th.
And
who's your lawyer in common police court,
November
Mr.
8th.
Carter?
Jason Smith, or Tyler Smith.
Who is it?
Tyler.
Tyler Smith.
Okay.
November 8th, Judge, I misspoke, is when this hearing is. Common pleas.
Well, how do you want to proceed on this? Do you want to hold it till after that hearing?
Well, the last time we were here, Your Honor, on the 20th, a week ago, I believe that maybe we at least discussed the idea of an OR bond plus GPS and treatment But we also knew that Common Police Court had a holder on him, and it would
So they
require...
have to be on board with it too.
Yes, now, I asked Mr. Bowen this morning, I said, he's on community control, so we're taking it to the grand jury. You've got a holder on him. Would we be okay with an OR and GPS and have him waive? And his answer was, our court placed a $15,000 cash bond with GPS on October 25th. That will work. So I don't know what that response meant because it didn't answer.
In other words, does he want the 15,000 or not? Was it 15,000 OR or 15,000 cash?
Cash. He just said cash, and he'd say surety, but I'm sure surety was included. But I guess my point is that this court could order the OR bond and the GPS and the treatment, and then let them decide.
That's fine.
I'm in total agreement, Your Honor.
Okay, so what I'm going to do, I had, or I think it was Judge Hall actually, it said 10,000 cash or surety. I'm going to change that to 10,000 signature bond. Order treatment as directed by Common Pleas. So they can send him wherever they like. And then come back after his hearing.
Yes, Judge, I'd like, and I will speak with Tyler and let him know what we've got going on here, Judge. And I think also you indicated you want to, or Mr. Hills requested an ankle bracelet. Is that going to be a requirement of the bond here?
Well, I think, didn't Common Pleas say there was an ankle monitor?
Yes.
I don't think we need to double.
Okay.
If they've already ordered it, I think that's sufficient.
Fair enough.
And so I'm looking at the 9th because the 10th is actually we're celebrating Veterans Day on the 10th rather than the 11th, even though 11/11 is the traditional date. It's going to be celebrated on Friday, so court will be closed on the 10th. So November 9th, are you available then?
I will be here, Judge.
All right, November 9th will be the next hearing for Mr. Carter in this court. There's a time waiver till then.
Yes, so wait.
All right, Mr. Carter, I don't know if you understood all that, but you got a hearing in Common Pleas on November the 8th. I'm letting you go to treatment with a signature bond, but you got to convince Common Pleas because as of now, they've got you on a cash bond. So you have to get them to agree or post the cash bond and then go to treatment. And then I'll see you back after your hearing in Common Pleas, which is November the 8th. The next day, I'll schedule you for a hearing in this court, November 9th. So if you're in treatment, hopefully I'll see you in treatment. If not, I'll see you just like I am now on telephone. You're welcome.
State of Ohio versus Tracy DeMint, case number TRC 1524 ABC and D, CRB 23624, CRA 23633, CRC 202272 A, B, and C, CRC 213522 A, B, and C.
Mr. Morford
Jason
Gilbert is on deck. Mr. DeMint's lawyer is Mr. Morford. This is actually set for sentencing today. He's already entered a plea some time ago on third offense OVI. And I was going to go ahead and sentence him today.
Yes, Your Honor.
I've just been handed a report on it. He was doing outpatient treatment at Bethesda. I've got a report I'm reviewing in my hand from Bethesda. It's like his last group session was October 1st. Last individual session was September 27th.
Hey, Josh.
They're recommending, in light of things that have happened, residential treatment. Can't hear you, sir. Bethesda is recommending you go to inpatient treatment.
Sir, I didn't miss any. I've been in jail, so the only one that I missed was those.
But Mr. Tapper, I need you to recuse yourself from me because of the conflict of interest for you to be my judge. And I need to reset this hearing, Mr. Hill, and I will be coming forward any treatment. I am not to non-comply. I've been in jail, sir. I was compliant. I don't do drugs. I'm not guilty of all charges being accused of me, sir. Please help me.
All right, Mr. Morford and Mr. Hill, if you want to respond to that.
Well, Your Honor, he has a case in common pleas court, and these charges...
Judge Ballard, I believe?
I'm not sure of that, but these charges implicate problems for him there. We're not trying to prejudge and say that we know he's guilty of anything. However, we know that he's charged. And so today is set not only for his sentencing on the prior charges, but also for a preliminary hearing on the current charge. Our trooper's scheduled to be here not only for this, but for a trial that we have today, but he's not here yet. I think that, I mean, our belief about this is that because he has a case in common pleas court already, which despite the fact that there's a lot of time that the court here can sentence him to today on the prior cases, that that situation in common pleas court, you know, it's on the horizon for him too. So we can have the preliminary hearing on this today, or he could waive, but we'd also ask for the sentencing to be done today on the prior cases.
Mr. Morford.
What judge?
Tracy, wait your turn. A record's being made and the court reporter can't decipher two or more voices at the same time.
Yes, sir. I can hear.
Judge, I don't know that I have much to add to what's been said or what's been written here at Bethesda. I mean, Mr. DeMint apparently takes issue with what Bethesda is saying, but you also have some positive tests for drugs during the course of the older DUI.
I had a stent put in, and all that was put in me at the hospital. Absolutely not. I did not do drugs. I smoke marijuana sometimes. That is all. I swear to God. They heard all this.
Judge, I would ask you to impose the minimums, Judge, as far as sentencing goes.
Well, we've got a motion to recuse from the defendant himself, not from counsel. So what I would like to do, I'm going to state what I understand the history is. It's a fairly lengthy history, and I'm going from memory here, but I think my memory is pretty good. I have had Mr. DeMint on several occasions from looking at the files. He has several files in this court, and I've been his judge on those. There was a civil case years and years ago where Mr. DeMint was the defendant in a civil action from a car wreck where a person that I represented was injured. He was the defendant. He did have insurance. There was no recovery against him. His insurance company paid whatever the damages were, which I don't recall. It did not go to trial. It was settled out of court. I believe I raised that at some point years ago when one of these cases first came up as a potential conflict of interest, in that I had represented an interest contrary to Mr. DeMint. And I believe at that time it was stated on the record that any conflict, which I'm not sure at this point it is a conflict because I don't represent any adverse interest to Mr. DeMint and haven't for years and years, and have been his judge on these cases for a long time. But when that was raised previously, there was a waiver of any, if there was a conflict. But what I would like to do, since I believe this is probably a surprise to you, Mr. Morford, since you didn't raise it.
Exactly, thank you.
I would like for you to discuss this. So it's one of the disadvantages of doing this by teleconferences. You cannot talk to him in person here in the court. I want you to call, talk with him, go over this whole issue. And I'll just say this, I'll consider it. If I do recuse myself, we'll have to contact the Ohio Supreme Court. They're going to have to find a judge to assign a visiting judge to come here. That's going to delay things for a while. So I don't know how that will affect things. But Mr. DeMint, I would suggest at this point that you remain, there's nothing really for you to say until you talk to your lawyer. Why don't you talk to your lawyer, You'll be brought back on the record then, and you can put whatever you want on the record then, as can your lawyer, and then we'll go forward with that. So you got a new issue, a recusal issue that's raised for the first time for years today. So I want to address that after council has had a chance to talk with Mr. DeMint. This case will be recalled.
Thank you, Judge. I'll call Mr. DeMint.
Thank you.
State of Ohio versus Jason R. Gilbert, case number CRB 23645 and TRD 193179 A and B. Daniel Lucas is on deck.
And Mr. Smith, this is I know you would remember, excuse me.
Is this my guy?
Well, in 2019, you were representing him in 2019 on case number 193179, and it looks like it's alleged that he failed to appear for a pretrial October 28, 2019. You were his counsel of record then.
Okay.
And he's got new charges also. So, sir, are you Jason R. Gilbert?
Yes.
Mr. Gilbert, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. That's where your charges are filed. You're appearing in the court today by teleconference on a monitor that's in the courtroom. Your image and what you say is on the record, which means it's all being recorded. If you say things against your interest, they can be used against you. You have a right to remain silent. Your lawyer from your previous cases here in the courtroom, Mr. Smith, you've got a new charge in case number 23645, case number that alleges that on October the 23rd of this year in Fayette Township, that you tried to deprive Walmart of property without their consent. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand that charge, sir?
Yes, sir.
I just spoke to Mr. Hill, and it might be, maybe I could call down and talk to him. I think he's been in jail for 4 days now. It's a Walmart case. I anticipate we can resolve it today.
Although we don't know what the old charge is.
Well,
he was going to Valley Health for some treatment. The last urine screen that I see from Valley Health showed a failure for Xanax, fentanyl, and gabapentin.
How old is that report?
In July of 2019.
Okay.
And then he failed to appear after that. So I'm going to appoint, well, let me ask you this, Mr. Gilbert, are you working?
Yes. I've went since 2019, Your Honor. I've been to treatment and then returned back. I live in West Virginia. I don't recall
Where do you work, sir?
I do a maintenance work at Huntington.
For who?
Myself.
You don't, so what do you make in an average week?
Anywhere from $350 to $550.
Do you have dependents? Do you have people you're supporting from your income?
No, not currently, sir.
You're a single person?
Yes, sir.
Are you Jason Ryan Gilbert?
Yes, sir.
Formerly of Pedro, Ohio? The prior case was Jason Ryan Gilbert, 9340 County Road 4, Pedro, Ohio.
Yes, I used to live over there, sir.
Okay, so it looks like the same person. When's the last time you worked?
About 2.5 weeks ago.
Do you have any money saved?
No, sir.
All right, I'll reappoint Mr. Smith to represent you on both matters. Let him call down and talk with you, then we'll have you back out after you talk to your lawyer, decide how we're going to proceed.
Okay.
State of Ohio versus Daniel L. Lucas, case number TRC 231414, A, B, and C. Ryan Plants is on deck.
And this is Mr. Smith's case also.
It is, Judge.
It's set for a pretrial.
It is, and Mr. Lucas is in the Gallia County Jail, but the Lawrence County's responsible for when they brought him back. This is alleged to be his 5th OVI offense since 2008. And I spoke with Mr. Hill, and plan was, that if we could get him out of jail, be directly to a residential treatment provider, he has an Ohio medical card. And I don't know who, he lives in South Point.
7208 County Road 1, South Point, is that your address, Mr. Lucas?
7208 County Road 1, yes. South Point, Ohio.
How do you pay for medical services?
Medicaid, or with CareSource, or I think it's CareSource. I'll have to look at it.
Have you been to treatment before?
No, sir, never.
Do you have a job?
I do some work with the Burlington Park there, where the Commons area is. I take care of the parks.
For the trustees, or who do you work for?
The trustees, Fayette Township. That's where the check comes from, it's the Fayette Township. I kicked the monitor, it was an accident.
So is the state that says there's 4 priors, but what level offense is this? Is the state?
It's a misdemeanor. It's the third in 10 years.
Okay.
You know, there's a high score, .163. It's a third in 10 years, a 5th lifetime. There's so many red flags on this that, you know, we take this very seriously. We like the idea of Mr. Lucas going to treatment, and the fact that he hasn't been before, I would say that this is way overdue for him to get into treatment and get this turned around. And despite the fact that recently we've had a case in which we extended hope to an individual that he would do well in treatment, and then it just blew up in our faces, basically. It's discouraging, but we're willing, if he pled guilty and agreed to go to treatment, we'd want to have him assessed to make sure that he would go to residential treatment. We wouldn't have an opposition to, if he pled guilty and was assessed for residential treatment.
I can't do that. I've not filed discovery. I've read, I just can't do it.
Well, if it's not today, it might be another.
Well, I mean, yeah, down the road, but if we could just do the bond or to residential treatment, I can do that today. I can't enter a guilty plea today without at least filing discovery and seeing if there's any issues with the case, which I filed discovery today.
What's the state's position on bond?
Well, it's $5,000 cash or surety bond. If he were to be released, we would want it to be with a GPS monitor as well, to treatment.
It doesn't sound like he has any income, Judge, if he's taking care of the common area for Burlington for the Fayette County Trust or Fayette Township trustees. I'd ask for an OR bond, at least only to residential treatment. Don't oppose an ankle monitor. But I don't know if he has any funds to even post any type of bond at this point.
All right. Who has mail? Okay. Mr. Gwynn was first to raise his hand, so I'm going to order you assessed by RRS, and if they're willing to take you, I'll release you on a signature bond and ankle monitor. Now, whether that can happen today or not.
Sure, I understand.
Sometimes ankle monitors don't go on very well on Fridays, or easily, I guess I should say. You get him assessed today?
Yes.
Okay. So I'll order release with the OR bond and ankle monitor, RRS, inpatient.
Judge, I'm here November 3rd, 20th, or 27th.
We would prefer it be sooner unless they're willing to waive time.
We'll waive time, but we can do it the 3rd. If that's just the day I can't get it till 11. I have a 10 o'clock in Magistrate Court across the bridge, but I can be here.
November 3rd.
Only other issue I had, and Mr. Hill and I have agreed, his car is currently in impound. It's a 2002 Hyundai. I think the impound fees are quickly going to exceed the value of the vehicle, and we've signed the proposed order that it could be released by to OSB to put a club on it at his residence in South Point. It's
Okay, you'll have to get towed there. You got somebody going to tow it? It has to get towed.
Yes, Harless Towing. He'll have to pay the impound fees today, pay the tow bill. put it at his residence in South Point, and OSP will put a club on it.
He's got somebody to help him get that done?
Yes.
Family?
Yes, right in the backyard.
Okay.
And he'll make arrangements. If I may approach, I've got an order prepared.
Yes. I'll approve your order. You'll need to get a copy of the order, sir, and take it to the impound and to the OSP. Okay, someone's going to come talk with you about treatment and try to get you in there today. I can't guarantee we'll get the ankle monitor replaced today, maybe Monday before that happens.
Thank you, Judge.
State of Ohio versus Ryan J. Plants, case number TRD 23-1541 A and B, CRA 19718, CRB 19719. Christopher Roadcap is on deck.
Okay, this is a recall of Ryan Plants on issues of bond.
Yes, Judge, we were here on Monday. At that time, we had requested to be released to residential treatment. Your Honor decided that might not be a bad idea, but wanted to wait until Friday, leave him in jail until today to make the final decision. We would ask that at this time he be released to residential treatment. And I can't recall if we talked about a provider at that time or not.
How do you pay for medical services, Mr. Plants?
Wow, that is.
Yeah, on Monday, he tested positive for cocaine, fentanyl, and
Yes. And you wanted to stay in jail till today, and we would revisit the issue.
Okay, are you willing to go to a faith-based program, Mr. Plants?
What is it?
Are you willing to go to a faith-based program?
Yes, sir.
Okay, Bethesda has room for you. Should we have an ankle monitor here, or probably need to because he's got a prior case that we covered here on?
I see a 19 case here, is that what?
Yes.
Do we have a current case too?
We do.
And I don't have the file for that.
23, it was 23-1541. It's a traffic case, but that's how he got arrested on the
It was a
run.
short clear distance. They asked for his license and discovered the warrant.
Then when he came to court, I tested him, and he tested.
So in the 19 case, it looks like a felony, so was it still,
It was a felony.
and he failed to appear at some point?
He did.
I think we just left it as a warrant to take it to the grand jury.
No, it was, the warrant was issued from here,
Yeah, I don't think it ever
rather
made
than
it
going
to.
to the grand jury.
Sounds like a GPS kind of case.
Yes.
No objection, Judge.
I'm gonna go look.
I know, but I need the case number.
Okay, I'll order him released to Bethesda, but with an ankle monitor. Now, one thing I should have told the last gentleman this. Once you put an ankle monitor on, that ups the ante. This is sense. If you leave and leave the ankle monitor on, it's bad. But it gets really bad if you cut the ankle monitor off. Usually people that leave with an ankle monitor, they cut the ankle monitor off too. That is a guaranteed trip to prison.
Yeah, I would do that.
Okay. I've never had anybody yet say, yeah, I'm going to cut my ankle monitor off and go to prison. But you know what? I have to give this speech all the time to people in your situation. And a small percentage of them still do it. They still cut their ankle monitor off. And I've got several of them that are in prison now because they cut their ankle monitor. It's going to be beyond my control. I won't file the charges. The state's going to file an F3 against you if you cut the ankle monitor off, and you will go to common police court, and they will sentence you to 3 years in jail if it's proven that you cut the ankle monitor off. And it's pretty easy to prove. It's strapped to your leg, and if it's not there anymore, they don't just fall off. So if you think you might be tempted, I say this all the time, if you think, oh, I'm going to really be tempted to cut this ankle monitor off, you'd be better off saying, Judge, I don't want an ankle monitor, I just want to stay in the county jail. Because there's no way you're going to go to prison now, probably. You'd have to really work at it to get yourself into prison. But if you cut the ankle monitor off, it's guaranteed you are going to prison. You understand me?
Yes, sir.
Everybody says they understand, but I still have people that do it. I don't understand that. I don't understand the thinking, how they think that that's not gonna happen to them, because I'm telling them straight up, it is gonna happen. I don't know if Corey Little's still there, but Corey Little is the latest one that did it. He stayed like 1 day in treatment, cut the ankle monitor, ran. He's bound for prison now. And he was there in the jail, so you can talk to Corey and he can verify it. I understand people that are on substances don't always think right, but man, this is a really bad decision. If you cut the ankle monitor, really bad decision. A few days of freedom is not worth 3 years in prison. I'm really harping on this because in the last 2 months, I probably had 3 people that cut ankle monsters. And they're all either in prison or they're on their way to prison. So, it's no joke.
Yes.
You understand?
Yes, sir.
And you're not going to do it.
No, sir.
Okay. Come back November 3rd?
Yes, Judge, I'm here.
So I'm going to see you on November the 3rd. You're going to be in treatment, get good reports. You can maybe even get this case dismissed if you get good reports and treatment, get in recovery. That would be the best possible outcome. You get clean and you don't have a felony on your record, nothing on your record.
Can I ask what facility I'm going to?
Bethesda is the name of it.
What is it?
Bethesda. It's local, it's here in Lawrence County. They're very nice people. They're gonna treat you right. You gotta treat them right, and here's the other thing, because I've had this happen. You cannot go there and start bossing the staff around and tell them that this is what I'm gonna do, this is what I'm not gonna do. Start bossing the other people that are there in treatment around. You gotta do what you're told, when you're told to do it, how you're told to do it. Otherwise, it's non-compliance. Do you understand me?
Yes, sir.
Okay. We'll see you on November the 3rd with a good report.
Thank you.
Thank you,
You're welcome.
Judge. I'm going to go call Mr. Gilbert.
Okay.
Hey, Roger, sign that. Yeah, you sign it. That's what happened, we used to do that instead of over here.
State of Ohio versus Christopher W. Rosedale, case number CRB 23646. Christopher R. Smith is on deck.
So are you Christopher Roadcap?
Yes, sir.
Mr. Roadcap, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You are appearing in the court on teleconference. Everything you say is being recorded, including your image is being recorded. It will be used against you if you admit something about your case. You have a right to remain silent. You have a right to have an attorney, to have one appointed for you if you can't afford one. You have a right to bail and make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Your charge is violation of a protection order. It alleges that on October 24th of this year, you recklessly violated a protection order or a consent agreement. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Yes, I did. I guess break it. I never did touch you, but I guess I did break it, I guess.
Okay, is that a guilty plea then? You're admitting you violated the protection order?
I'm not pleading that I'm guilty.
Okay, I'll enter a not guilty plea then. Which is your right. You have a right to enter a not guilty plea, and that's what I'm going to enter. Do you want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
No, sir.
Do you have no income?
No, sir.
I'll appoint Mr. Morford to represent you.
Okay.
He's right here in the courtroom, so he's heard what's happened so far. Now, I've got you living at Willowwood, is that right?
Yes, sir.
Christopher Roadcat. Violating protection order. Clarence Mahan as a protection. Clarence Mahan is a protection order.
He's here. Mr. Mahan's here.
Okay.
Okay, so apparently there's a order that you stay away from Clarence Mahan, is that right?
Yes. Yes,
Do you all live together, or?
No, he lives up the road from me, but he has been driving, he drove down past the house. Everything, he has harassed me, everything. I don't know what happened.
Your Honor, we have a trial coming up in which Mr. Mahan is a defendant. And I believe that this is a little bit too, we're going to have to ask for a special prosecutor on this one.
Okay. All right, I'll appoint Mr. Ashworth. When's the trial set? Yeah.
It's within the next couple weeks, I believe. I can look it up.
It's on the 3rd, Your Honor. Mr. Mann's here.
All right, why don't you come, well,
To this case.
so you have a case where you're a defendant.
Yes.
You step up here.
Does that involve this gentleman also?
No,
or
sir.
Another?
No, sir.
Your Honor, can I get out there?
We'll talk about bond in just a minute, Mr.
Well,
Roquette.
that's what I got to decide. Can you stay away from Mr. Mahan?
Yes, I will.
Well, why didn't you? Well, don't answer that question. But was he drunk? What's the allegation there?
I'm not sure what was wrong with Mr. Roquette.
Okay.
Do
you all live close to each other?
There's probably a mile and a half between residents.
Okay.
Yes. But I was doing a cookout for a 15-year-old autistic kid, and that's when Mr. Roquette
showed up,
jumped out of the weeds at that residence, and
Sir, don't talk.
Started to attack the 15-year-old child. Then he realized it was not me. Then he come around the truck at me with the ball bat.
Okay. Well, that's kind of disconcerting.
When this comes to court, I do have video of the whole altercation.
That you will give that to?
I will, yes, I'll get it on CD and present it to.
What I want to do is, we'd like to, if I could get Mr. Mahan's information to be passed on to Mr. Ashworth, then they can get in contact with one another for that.
Okay.
Mr. Roquette, while the judge is deliberating, sir, can you tell me your telephone number?
740 643.
643?
Yeah. 2058.
Thank you.
Your number, you don't know your number.
Yeah, I've got it. I can't.
Sound like me.
Okay, under the circumstances, in light of this alleged, looks like pre-admitted violation, I'm going to order a $1,500 cash or surety bond and a GPS monitor, because they can put it in a zone, and that he has to stay away from Mr. Mayhem. Do you think you can post a bond, Mr. Rudcat?
I ain't got 10% of that right now.
Well, then we better come back pretty quick.
Judge, we also tell him about penalty for monitor removal if he were.
Yeah, if you remove the monitor, then you're going to be subject to a felony charge if you cut it off.
But if you put a monitor on me, then yes, I will stay away from it.
Well, that's the whole reason I'm putting the monitor on you, so you'll stay away.
Oh, no. Oh, no.
So I'm going to set bond at $1,500, cash or surety, with ankle monitor. And let's come back pretty quick, because I don't know that he can meet the bond. And probably, good chance he's still going to be in jail.
I guess Mr. Ashworth's going to need to be
that's true.
apprised of this too.
We'll have that emailed to him today, and hopefully he's available. Let's see. 6/1, half a dozen the other. November 3rd, so a week from today will be the next hearing.
Your Honor, can the court give Mr. Mahan Mr. Ashworth's number too?
Yes.
This is a violation protection.
304-634-8523.
8523. So now listen, the court's going to tell him that he's a special prosecutor.
304-634-8523.
Yes.
So you might want to wait until like 11 or something.
I'm texting him right now to let him know.
So that file just needs to be given to him against her.
Yes.
Okay. I was wondering about that.
I'm texting Mr. Ashburn, taking copies of the complaint and affidavit. And we'll need to also email the file to him too. But as of now, November 3rd, for pretrial 10 o'clock.
Thank you, Your Honor.
You're welcome.
Judge, before you have Mr. DeMint recalled, may Mr. Hill and I approach the bench?
Yes.
State of Ohio versus Christopher Smith. Case numbers CRA 23647 A, B, and C, CRB 23561, and TRD 231564. Tracy DeMint is on that.
He's like what I said to him last time we reported, I don't know if that was Monday or last Friday. I don't think technically what are his grounds is that case involved him as a civil defendant process. And he's still they really haven't judged his cases since then. I think I raised it some time ago, I raised it, just to put it out there, and then at that point, there was a waiver. We've been over, how many other courts will let somebody on third offense go to treatment until life sentencing like we have to try to get him? I wanted him to be successful. He's got some abilities, but he's also a manipulator. So, you know, all the other problems are. I haven't talked to him since it was. That's why I was going to stay on 60 days. Third offense. Then that gives you something. Are you sure? I don't think you were not in, it's kind of ridiculous. I don't know if I should bring it up, but I was, so I think, you know, cannabis in jail, it's jail ministry through the TFC. So she was at the stage, she was really angry. Because he was still in jail. He said he was going to send me for $2 million. He's gone. He hasn't. I said, well, he hasn't changed his attitude. He says, I think that's worse. Like, oh, I've made a mistake. I need to change my ways. That he has no attitude like that. And I read that report this and that's what I kind of got from a prejudged case. It's almost comical what he's doing. Two guys trying to slow it down, like he can drive his own car, he wrecks it, and then they take off, and then police go to his house, and his keys are right there on his nightstand, and they put his mark in.
Thank you.
You're welcome. Okay, we're back on the record with Christopher Smith. You are Christopher Smith? Okay, your audio is turned off. I see your lips moving, but nothing came through. So there's a switch on the headset that probably needs to be turned on. right now. Say something, please. Are you Christopher Smith? Okay. All right, Mr. Smith, I'm Judge Capper. This is your arraignment hearing. There are several files here. We're going to go through all of them. But before I do that, I want to make sure you understand your rights. You have a right to remain silent. You don't have to say anything. What you do say is on the record. It can be used against you if you admit something about these cases. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio prove any charge against you beyond a reasonable doubt. Do you understand those rights? Okay. First case that I've come to is 23-647, A, B, and C. 647A alleges that at Fayette Township on October the 25th of this year, knowing there was a proceeding or investigation in progress, that you did alter, conceal something with the purpose to impair its availability as evidence. So that's tampering with evidence is the charge. It's a third-degree felony. Maximum penalty is 5 years in jail and an $8,000 fine. Next case, 23-647B, alleges that at Fayette Township, also on October 25th, you knowingly acquired, had, or were carrying a firearm while you were under indictment for or had been convicted previously of an offense involving possession, use, sale, administration, distribution, or trafficking in drugs of abuse. So that's having a weapon while under disability. It's also a felony of the third degree. Maximum penalty, 5 years in jail, $8,000 fine. 647C alleges that on October 25th in Fayette Township, you knowingly were in possession or obtained methamphetamine. It's a Schedule II substance. That's a felony 5. Maximum penalty, a year in jail, $2,500 fine. Okay, so that's one group of charges under case number 647. Then there's another group under 23-649.
Yep, same thing.
23-649 is an endangering children charge. It alleges that on October 25th in Fayette Township, you were the parent, guardian, or person that had custody or control over minor children, and that you created a substantial risk to their health or safety by violating a duty of care, protection, or support. Endangering children is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Next case is 23-561. That is a domestic violence complaint. This is a different date. This alleges that on September the 7th of 2023 in Perry Township, that you knowingly caused or tried to cause physical harm. Well, I think this is wrong. Okay, maybe it's not. Maybe it's a son. But I think it should be Christopher Sean Smith. The defendant is Christopher R. Smith, and from the affidavit, it looks like the alleged victim was Christopher Sean Smith, who is the father of Christopher R. Smith. Yes. So, do you wish? No, it is correct. I just meant read it wrong. The complaint is correct. It alleges that Christopher R. Smith at Perry Township knowingly caused or tried to cause physical harm to Christopher S. Smith, who would be the father. Domestic violence is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. And then finally, there's a traffic charge.
I have a CRB 23648. Do you have that chart?
I do not.
Okay, let me get that one there.
I've got TRD 231564.
Yes, I have that also.
And you have the endangering charge.
Yes, I just ran him on that. Okay, this charge, the traffic charge, 231564, alleges that on October 25th at 7:53 p.m. in the village of South Point, that in violation of village ordinance, Mr. Smith was driving a vehicle and not displaying tags. That's a minor misdemeanor, maximum penalty is $150 fine. And what's the 648?
It is
Okay.
It's the same. It's the same.
And also, on the October 25th date, which is Fayette Township, it's alleged, Mr. Smith, that you resisted the lawful arrest of yourself. That's a second-degree misdemeanor. It's case number 23648. Maximum penalty for that, 90 days in jail, $750 fine. Do you understand these charges, sir? There's a lot of them, I understand. Do you have the money to hire a lawyer? Do you have money with which to hire a lawyer? Do you have a job?
Yeah.
What do you do?
Sir. I used to work in DoorDash and then also Charter Foods, which was Taco Bell. That's the company that paid me Charter Foods.
What are you making an average week?
I mean, the Instagram, you can make anywhere from 100 to 400 a day. And then DoorDash, I'd say maybe weekly, probably 500 to 600.
Do you have any money saved?
Christopher S. Smith is the father.
I'm not sure, I'm not the best managing money to my mom, they always have all my savings accounts and stuff.
All right, Mr. Smith, I'm going to appoint you to represent Mr.
Yes, sir.
Christopher Smith.
Yes, sir.
State's positional bond.
Your Honor, we're going to request a $15,000 cash or surety bond and a protection order to protect Mr. Christopher S. Smith.
Judge, I will discuss the matter of bond with Mr. Smith, and if there's a bond he thinks he can make, I will have it called back up.
Okay. At this point, I'm going to set a $15,000 cash or surety bond with a protection order to stay away from Christopher S. Smith.
Judge, I am here November 3rd in case he does not postpone. That should get us within the 10 days.
I'll set it for November 3rd.
Thank you.
Preliminary hearings and pre-trials.
May I ask about what that means? I need to cash a surety. What's that mean?
Your lawyer's going to call down.
I'm going to call down and talk to you once we get out of court here within the next probably 10 minutes. I'll be calling you at the jail. We'll talk. I'll answer your questions.
And I believe there might be family here in the courtroom. The family for him? Okay.
They say his mom was
All right, well, if Mr. Smith wants me to reconsider bond, I'll do that later in the docket. Otherwise, it's set at $15,000 cash or surety with a hearing 1 week from today, November 3rd.
State of Ohio versus Tracy Dement on a recall at the Lawrence County Jail. Case number PRC 231524 ABC and D and others. Jason Gilbert is on deck.
All right, this is a recall after Mr. Morford had a chance to talk with his client, Mr. Dement. So
Yes,
let's
sir.
bring up the first issue I asked you to discuss was recusal. How do you wish to proceed on that, Mr. Morford?
Judge, after talking with Mr. Dement, I don't find that argument holds any merit. The matter that you were involved with, Mr. Dement, occurred some years ago. It was probably a traffic accident, if I recall correctly. You didn't represent him at that time, and now we're on the other side of him or anything like that, which is the typical kind of conflict. I know he wants to pursue it, Judge, but I don't find any grounds to support it, and I can't stand
No,
before you
no,
and get
no,
paid.
no, 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 I did not say.
Okay, so you're withdrawing your request for recusal?
Yes, sir. Mr. Capper, I would just ask that you give me the benefit of the doubt. I would love to continue my treatment. I was doing so great, Mr. Gill, Mr. Capper. I did not mess up. I would love to continue my treatment, graduate that, delay sentencing till next week so I can do some things. If you want to sentence me then, fine. I'll go inpatient whatever you want. But I don't need that. I don't do drugs. Mr. Cooper will tell you I don't do drugs. Test me right now, whatever hair follicle, but I don't have no drugs in my system other than putting at the hospital and these procedures I have. That is all, sir. And I haven't had my medication. I'm supposed to have, I could have something happen here and die if I don't get everything. I just want to get to the doctor. I missed appointments. I did not miss none of my appointments until they arrested me, sir. I went to all my the counseling, my groups. I enjoyed going down there and talking to people who evangelize and provide treatment. I do a tricycle church twice every Sunday. I'm sorry, sir, but you take over, Mr. Capper. I'm supposed to be doing.
All right, so the request for recusal is withdrawn, so obviously I'm not going to recuse myself. There's not an active request for that, and I don't think it was merited anyway. So
I'm sorry.
at this point, then I think we'll go ahead and we have two issues before the court. Sentencing on the prior third offense OVI that's been pending for a long time, and then we've got a new OVI charge, which is filed as a felony, or is going to be filed as a felony.
We have filed it as a felony.
That's 23633, and it's set for preliminary hearing today.
Yes, sir.
Now,
And I pled not guilty, sir.
noted. So how do you want to proceed with the preliminary hearing, Mr. Wolford?
Judge, I believe it would be probably best if we had a preliminary hearing.
All right, is the trooper here?
Is Trooper Bean back there?
That's in the trooper, yeah. It's not quite 12 usually. He's usually here within the next 3 to 5 minutes. He's usually right on time.
Okay.
Then there's also the matter of sentencing on the cases which he's already pled. I don't know how the court wants to proceed on that. But
All right, let's go ahead. We can do the sentencing then. He's already pled guilty on 220548, which was the third offense, OVI.
Can I have, the section number is, what is the, is it 4511?
Yes.
Because it's not in there.
There was a dismissed case against me. You guys say I'm guilty and I was not. Sorry.
Well, you've already entered a plea on this one. There was another case that was nolly. This wasn't the one.
Yes, Your Honor.
And the court has allowed Mr. Dement to go to treatment on this third offense, which has a mandatory minimum penalty of 30 days in jail, but he did not serve that. I allowed him to go to treatment for quite a while. And we got some pretty good reports for a while, but now we've got a fourth offense OVI pending. And also I've got a report from Bethesda now that says he has not attended since September
I've been in jail,
27th.
sir. 41 days I've been in jail, I have not been 3 times yet.
Tracy, let the judge finish, please, before you say anything.
This last offense allegedly occurred, I believe, October 15th, so.
Yes, Your Honor.
So does not appear to jive with what Mr. Dement's saying on the record. It was more than 2 weeks after his last treatment at Bethesda. All right, State want to argue on the sentencing on 220548, which is the third offense OVI.
Your Honor, if it please the court, I don't guess a long-winded explanation of the history is necessary. We wanted and still want Mr. Dement to find a new way of living where he's not endangering people and he's not putting his own life at risk. This new situation, he had to be Narcaned, his truck hit looks like a utility pole maybe, and I mean, he could have killed somebody or himself in this incident. We feel that our agreement on the prior cases was that if he would be successful in treatment and see that to its completion, that we would want to offer a resolution that would be a little bit better for him than what would be if it were just strictly based on the charges that were original. But we don't feel that he's lived up to that. So our request is a sentence of 6 months in the county jail. And we also have a felony case that we intend to go forward to the grand jury on. And he's already on community control sanctions in the common police court. So regardless of how much time he ends up doing, either on this, if the court orders 6 months in this case, or he's found guilty on the new felony case, or he's got time hanging over his head on the common police case, whatever that happens to be, we would still, even at this point, want to see him take a sincere effort and show improvement in treatment and be able to plead his case later on, that maybe he's deserved to go to treatment instead of jail. And, I think my experience practicing law, both as a defense attorney and as a prosecutor in this county, if a person is making a sincere effort at rehabilitation, that's always taken into account. So that's all that we are able to offer today as far as a request is 6 months in the county jail.
Mr. Morford.
Judge, we'd ask you to impose the minimums. Mr. Dement is a businessman, has a business, has a couple of employees at least. He's also a family man whose family is dependent on him for their support. I think it may be fair to say that he has substantially complied with terms of treatment. There's been a problem here and there, but he, in my conversation with him earlier, is adamant that he wants to return to treatment.
All right, Mr. Dement, you have a right to make a statement if you wish before your sentence. Do you have anything you wish to say? Oh. Okay, go ahead.
Sir, I would love to do my treatment and be not in jail, sir. I don't need to be in jail. I'm not a criminal, and I'm no judge of nobody. I promise. Whatever you want, whatever you got to do, I just want to take care of my family and be a good citizen.
Okay, well, I got to disagree with those last statements. When somebody gets 4 OVIs, you are a threat to the community and to yourself, to everybody else that's on the road, to my family, to me, everybody that's in this courtroom that uses the highways. You're a threat to them. So that statement is patently false. And I think that's part of the problem, Mr. Dement. You have woefully failed to be self-aware of your problem. You still have not admitted you've got a problem. And from my observations, I've muted you so you're talking to yourself. I've observed you for years. And there was times when I felt like you Maybe we're getting it, but I was never sure. This just confirms you were not getting it. You never adopted a willfulness to change your, a willingness to change your way of living. You were always about getting out, not doing inpatient treatment, and minimizing your jail time. And I think that's still the thing today. You have even said as much. You don't have a problem. You've got a serious problem. And the first step is admitting it. You haven't admitted it yet. So I would also say this, on a third offense, I mean, you should have been scared to death. One, you're already on probation and common pleas. You were not scared. Not scared at all. You're on probation and common pleas. You got these cases pending here. This is, I can sentence you to up to a year on a third offense OVI. And you acted like you could just do whatever the heck you wanted to do. So, I'm going to impose the 180 days that the state's asked for. I hope at some point there's a change in your attitude. I think you've got a lot of potential ability, but you're going to have to change your attitude. You're going to need some time to do some introspection, look at yourself, look at how you need to change, and make some changes. And the first thing, you got to admit you got a problem. You've got a serious problem with substance use, just from what I've seen. And that has to be dealt with. You have not dealt with it in an honest fashion up to this point. So 180 days in jail. I'll give him credit for, he says he's been in jail 21 days. I'll give him credit for 21 days. So he's got a balance of 159 days at this point. Third offense, I'm giving him a $1,000 fine. I'm going to suspend his license for 5 years. And I'm only going to give them back to you when I'm convinced you've dealt with this and you're not going to be a menace to me, my kids, my grandkids, and everybody else that's out on the highway. And you can come back and convince me. And I hope, you know, you're going to be in front of Judge Ballard, at least on your old case. I don't know if you'll have the new OVI or where you'll be on that. But maybe you'll have a chance to go to treatment down the road. And I might be willing to lift my jail sentence to accommodate that in the future. But it's going to be a while.
You're going to have to have some change of thought, Tracy, before Judge Capper would consider that.
All right, then he also had a safety belt, so that's a mandatory $30 fine. No, take out, he's not doing any assessment or anything like that, so that comes out. Okay, so have you got this in as a, this should not be a first offense?
It's the third.
Yeah. So his license suspension is going to
Days.
1,825 days.
How much?
1,825 days, 1825. So it didn't take.
It didn't have any dates in it to begin with. Do you want me to start it from today?
You can start it from the day of his offense, which is March 1st, 22. Yeah. No, okay. Back up. On the jail days is right. Suspend, you got those terms in. Suspend 150, it's not suspend. Suspend 0.
Oh, I'm sorry.
Credit for 21. There we go.
Anything else other than a review?
We can do a review hearing April 26th of 24. Now, there was a felony also pending, oh, Mr. Hill was also.
He's talking to Trooper Beam.
Okay. There was a felony possession, I believe. No. There was a misdemeanor possession. Okay, sorry. On that 220548, there was also there should be a control. It's a misdemeanor control substance. There it is.
Oh, well, we'll need to nolly that to the grand jury.
But it's just a misdemeanor.
Yeah, but I think it arose at the same time.
Okay. Well, it's with the one I'm sentencing on, not the.
Oh.
What is that number, Your Honor? 22?
Well, you had it up there.
I did.
Yeah.
It's on, okay, so we can, I guess, nolly that one, if that's the question.
Well, it should be the C case then, 220548C. It should have been filed as a CRB because it's a possession.
Just have a seatbelt theft control under that 22548.
Okay. Well, dismiss the, because I don't even see the failure to control. Yeah, it was on here. So on the failure to control, because there was a wreck, you can do a $20 fine.
And then the C was the seatbelt, you said 30.
30, and it's tagged in the file as a TRC case, but it should have been a CRB. It never got filed.
Okay.
The possession, he had a possession of marijuana file. So I'll just mark it as not filed. Okay, so that concludes that third offense OVI. Let's see what else was there. He had already pled to TRC 213522, so I'll set it for a review hearing April 26th of 24. Same date as the third offense. 2272 was the first offense OVI, and I'll mark it completed.
22 what?
2272. So I'm not going to set a no review hearing date on that.
Case complete.
So 231524 was the new case. It was filed initially under and then it became a felony. So 231524 can be nollied, the TRC case number.
23 what?
1524. 23633 and 624 are the felony and felony OVI and possession of controlled substance M1. So those are still pending.
Those are still pending, and since he's been sentenced to 6 months in jail, we'll be able to present this to the grand jury well before the expiration of that term. So we're going to go ahead and nolly these to the grand jury.
Okay, 23633 is nollied to the grand jury, as is 23624.
Thank you, Your Honor.
You're welcome. Okay, that's all.
State of Ohio versus Jason R. Gilbert, case number CRB 23645.
Josh, you feel bad on this one.
CRD 193179A and B.
This is Mr. Roger Smith's case, and you've had a chance to talk with Mr.
I did, Judge, and done a little bit of homework on this. The felony that was back in 2019, apparently, looking at court view, he tells me that was sent to the grand jury. It shows on 8/28/2019 transcript from this court was sent down to common police court, posted bond with Mr. Sowers. The case is resolved by a guilty plea on November 27, 2019, meaning he's still on probation. He had a new charge filed. As I understand it, at that time, Mr. Morford was his lawyer. Currently, his lawyer in common pleas is Luke Steyer. He had a hearing just 2 days ago, and they're coming back on November 8th, but I understand in speaking with Mr. Gilbert that they're going to send him to treatment. They've already resolved the probation violation. Is that correct, Mr. Gilbert? Okay. Talking about his old case. It did go down to common pleas.
I mean, is this something?
Yeah, he's got a shoplifting too. He's going to guilty plea too.
Is this one we talked about already today?
I had a good talk to him on the phone.
Oh, okay.
Try to figure out what was going on with the felony.
Oh, okay.
But
Here it is.
But apparently I was his lawyer at one time, then Mr. Morford in common pleas, that was resolved, and Mr. Steyer now has him on a probation violation. You go back to court November 8th?
Correct.
And you have worked out, your lawyers worked out an agreement you're going to go to treatment?
That's correct.
So I think what we have the Walmart theft case.
Well, this just happened, though.
The 23rd, he was in
That
court.
was Monday.
The court, 25th, he was in court.
Was he out on bond when they did this?
Gary Sowers posted is what it looks like. Did Gary Sowers post your bond? I know one time he did.
Or I should say when this allegedly happened.
Yeah. Because what I'm looking at court view now, there was a hold placed on him on October 24th, which had been the following day, I guess, because he got arrested on the 23rd. Hold was placed on him by Carl Bowen's office. He appeared at arraignment on the 25th, this past Wednesday, in front of Judge Finley, and they continued the case out for a CCS trial, it says, November 8th, but he tells me they kind of worked it out at arraignment. He's going to go to treatment. But he was out on bond when this happened, allegedly happened, Tuesday.
So we have a 19 case is still pending, felony case.
Traffic case.
Oh, traffic.
The felony already went to common pleas, and it's back in common pleas for
Failed
probation.
to appear here, it's alleged, for pretrial, October 28th, 2019. It was it was a first-degree misdemeanor, driving under suspension, and a failure to control, so there was a wreck. It's like, yeah, there's a crash report. Looks like a single-car accident, though. His car was out of one.
Treatment on that day, out of state.
Is that in West Virginia?
Yes.
I have a report from Valley Health, October 28th, 2019.
I did see it.
Do you want to see it or hear it?
I saw the court file. It wasn't great. I did look at it in the court file.
He was tested for fentanyl. That's early for fentanyl. Tested for fentanyl then, 2019.
Pre-COVID. I didn't think it was around then, but I guess it was.
Xanax, fentanyl, and gabapentin.
He's still alive, believe it or not. Well, Your Honor, he's going to be in jail, it sounds like anyway, for at least a period of time on his common pleas court
So
case.
what bond did they set for him?
There's a hold on him out of probation. They give you any kind of bond this past Wednesday? They still have a hold on you out of Carl Bowen's office?
They didn't double hold me, so they wouldn't release me.
I would imagine. If he failed to appear, they normally would have a hold on him. So you're going to stay in jail till the 8th, and Mr. Steyer is going to represent you again in common pleas.
I believe they're going to release me to treatment on ankle monitors prior to the 8th.
Well, if we get this resolved, I guess they could. We still have this pending.
That's just, yes,
Okay.
obviously, but that's what they said.
If he were to plead guilty today, Your Honor, our recommendation would be 30 days in jail. It could be modified to a suspended sentence if common pleas court puts him in treatment.
No objection, Judge. You understand that, Mr. Gilbert? If you enter a guilty plea, we talked about a guilty plea on the phone. If you enter a guilty plea, the state is going to recommend the prosecutor down 30 days in the county jail, but if you're getting out the treatment, he's not opposed to that being modified to allow you to go to that residential treatment. If for some reason that falls through, you owe him 30 days less the time you've been in, so like a couple days. But that's what the state recommends. Do you still want to do a guilty plea as we discussed?
Yes, that's right.
We would change the guilty plea and hopefully get this cleared up to allow him to go to treatment.
All right, anything you want to tell me, Mr. Gilbert, before I sentence you?
I just want to do it.
Okay.
What are you going to do first, Charlie?
What about the old case? We guilty to that also?
Yes, Judge, if we could just work it in together, some kind of concurrent sentence, that'd be fine.
All right, so let's start with the TRD 193179 A and B. Okay, I'll impose a $200 fine. Court costs. $30 days in jail. And he's been in since Monday. So give him credit for 4 days served, suspend 26. Review hearing April 26th of 24.
Wanting to do community service?
No.
So you said 2 years low before?
Yes. $20 fine. Okay, and then now we're at the current theft charge. 23,645. I'll impose a $25 fine. Order the cost be paid. 30 days in jail. uh, 26 suspended, credit for 4. Stay out of Walmart. $30 community service. Treatment as ordered by common pleas court.
That's it, Judge. I do have Christopher Smith. We don't have to recall him. I spoke to his mom. She can't post any cash surety bond. It's already set for November 3rd. I'll give the file to Vivian.
Okay. I think that finishes up at the jail. We're finished at the jail.
State of Ohio recalls Jade Lewis. State of Ohio recalls Jade Lewis, case number CRA 23432 A and B, CRB 23433 A and B.
Dangerous stuff. So what are we gonna do about this?
Well, Your Honor, our recommendation would be that she does treatment outside of outpatient because that hasn't worked for her and she's continuing to use, so.
See the results?
I was told, Judge.
I offered her the reflection program. She said she needed time to think about it.
Okay. Well, you've got a possession charge,
Yeah, I know.
so you're gonna have to think quick, because I'm gonna remand you into custody if you don't agree to go into
Okay.
treatment. Because I'm not gonna let you die on my watch. I mean, you're
I know.
playing Russian roulette.
And I was just telling her after, when I did it, because I'm gonna be honest with you, I did it about 2 days ago. And after I did it, it wasn't even worth it.
Yeah.
It wasn't even worth
Agree with
it.
that, 100% I agree, it's not worth it.
Yeah, it wasn't even worth
You're
it.
risking your life.
Yeah.
Any drug you get off the street now, you're risking your life by taking them.
Especially what she's using.
Well, she probably didn't even know, you don't know whether you're,
No, you don't even know what you're getting.
you don't know
anymore.
when you're getting fentanyl or not.
Yeah.
So, we're,
Well, unfortunately, I don't believe OVP has a female bed available today, so I was going to see if there was another treatment program here that would be willing to take her.
Your Honor, I know Mended Breeds does. It would probably be, I would see if they could take her today.
okay, you want to make some calls? Good.
Yeah, I can call and see, but I think we have female beds.
Bethesda as well, so either way.
So we can talk to her and see kind
Why
of
don't you all
what she's
talk,
willing
and then
to
let's
do.
come back and finalize things.
All right, thank you, Your Honor.
You don't have a lot of cards here, Ms. Lewis, you need to agree to treatment.
State of Ohio recalls Charles Hutchinson.
All right, got a screen for Charles. Bad reports too. From Lawrence County Recovery. They say he tested positive for fentanyl on 2 different occasions, October 4th and October 10th. Then you get here late, they think they've already left.
I believe so, Your Honor.
Any explanation or statement you want to make?
Well, in the same note, it should have said the levels were coming down because they've been clean for 30 days.
Well, I think at this point in your life and what I've been through, there's got to be some consequences. So I'm going to send you to jail for violation of the terms of your treatment. And I'll see you on Monday, teleconference, the 30th. We'll put him on the docket for October 30th. He's remanded into custody at this point.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Harry M. Rude. This is an arraignment, Your Honor. Case number TRB 22805 A and B, CRB 21392 A and B.
Which one has case numbers on that?
All right, Mr. Rude is case, you missed a review hearing Monday, looks like.
Yes, sir.
On 220805, which was speed, and 21392, disorderly conduct. Do you admit that or deny it, that you missed your hearing?
I admit, yeah.
Do you have an explanation?
I forgot, I've got some family problems going on. I got a paper from the, I had my disability hearing on August the 31st. It got rescheduled till January the 5th. I tried to get the paper Tuesday, and she said that she didn't know where it was. So, like I said, I haven't been home for a couple of weeks. And
Where have you been?
I mean, I've been staying at a friend's house. I'm just having some family problems, and I just stay away from the house so things don't get any worse than what they are.
Can you pay anything on your fines?
Not today, no. No, I'm not able to work. I had to walk here today.
From where?
By the fairgrounds. I got to ride to the Braddock intersection, and I walked from Braddock to Pass, and Pass gave me a ride to here.
Okay. It's a good little walk, I see.
Yeah, it was pretty
About
good.
5 miles probably.
Yeah. And I got to walk back. So.
Okay, I'll make your next hearing November 13th.
Okay.
9 o'clock, November 13th. No warrant for you today.
Thanks, sir.
You're welcome.
I'll try to get that paper and bring it in. November what?
13th.
Okay.
State of Ohio versus Scott Taylor, case number PRC 222629.
And this is Mr. Smith's case.
Thanks, Your Honor.
You're welcome.
Doing all right?
Huh?
You doing all right?
No, not really.
What happened to you?
Cut my finger off in a leaf blower.
I'll grab a letter real quick from OVP he
The
gave
shed
us.
was
It's on the front copy machine.
They sewed it back on at the knuckle.
No kidding?
Yeah, it had a rod in it. It happened a month ago.
Oh, Lord.
It's been a pain. Yeah,
How's your mom?
she's doing okay. She just turned 88. And it's,
You know how old my mom is?
yeah, she's 88. Everybody thinks she's 64. Huh?
My mom's 97.
Oh, awesome.
Everybody thinks she's 88.
That's right, yeah. That's incredible.
That's good.
We looked at it earlier, you probably forgot. Just my approach, I've got a letter from OVP that is dated, looks like Wednesday.
Okay. Okay, that's good. Screens are good.
Do you have any idea how long you're going to be at OVP? They told you now?
November 27th?
I'm here, Judge.
November 27th, 10 o'clock.
November 27th, make sure I get another report before the 27th. 27th. You're right, okay. Make sure you're not left-handed, that doesn't look good.
It's been rough. Get the rod taken out. I got sick.
Get another report to me, keep it up. You're doing well.
His finger.
He's not like two of my kids are right. Even statistically, probably one of them should.
It's a genetic wonderment, is what it is.
State of Ohio versus Thomas Jarvis, case number TRC 23972, A and B.
This is set for trial today. Mr. Jarvis is here. You don't have counsel, I take it?
No, sir.
You ready to proceed?
Yes, sir.
Ready to proceed?
Yes, Your Honor.
You can pull up a chair, Mr. Jarvis.
The only thing is we'll have to have our jump drive put in on the screen.
You need Mr. Major for that?
Yeah, probably.
We have the jump drive.
Wes is getting,
Okay. Your Honor, if we're ready to proceed, we'll call Trooper Beam.
All right, Trooper, if you'll come up, I'll swear you in. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? I swear. That, afternoon.
Thank you, Your Honor. Trooper, state your name and where you are employed.
Trooper A.J. Bean with the Ohio State Highway Patrol's Ironton Post.
Were you on duty on July the 16th, 2023? Make sure that's right. Yes. And at that time, did you have contact with Thomas Jarvis at approximately 3:43 in the morning?
Yes, sir, I did.
Were you on US 52 westbound in Perry Township, Lawrence County, Ohio?
Yes, sir.
Do you recognize Thomas Jarvis in the courtroom today? And if you do, can you point him out, please?
Yes, sir. He's right there.
Record will show you pointed to the defendant.
What caused you to first have to notice Mr. Jarvis?
I was traveling westbound on US Highway 52, and there's two cars traveling ahead of me. The one situated behind the first one was following that front vehicle at an estimated length of less than 2 car lengths while traveling at 60 miles an hour. The golden rule is for every 10 miles an hour you're traveling, you need that many car lengths. So 60 miles an hour, 6 car lengths. I estimated there was less than 2 between the vehicle behind the one in front.
Is traveling too close behind another vehicle, is that a traffic offense?
Yes, sir.
The cause of seeing him traveling too close behind another vehicle, did you initiate a traffic stop?
I did.
Now, would it be fair to say that in any situation in which you were going to stop a motorist for a traffic violation, that the possibility of an impaired driver is on your mind?
It can be. I mean, it's, you know, as I always say, I'm looking for pieces of the puzzle, and that can be a piece of the puzzle. It can be an indicator of impaired perception and judgment in terms of what's safe to follow behind somebody.
So in this case, did that trigger maybe the first piece of the puzzle?
Yes, sir.
Risk-taking behavior, is that what would be coming to the category?
Yes, sir.
Now, is your patrol vehicle equipped with video and audio cameras, one facing forward from the dash cam, or from the dash, one facing the back seat of your cruiser,
Yes,
and
sir.
body cam?
Yes,
Are
sir.
all those operational at that time?
Yes, sir.
And did they keep video of this situation that we're talking about today?
Yes, sir.
And did you upload all that to the system for use in the hearing today?
Yes, sir.
And did you watch all of that video prior to the hearing today?
Yes, sir.
If you don't mind, as we're watching this, if you could tell the court what you were seeing there at that time.
So we're approaching a solid exit now. This location here. I believe that's Trooper Martin directly in front of me and the two vehicles I was watching in front of him.
So is that Trooper Martin's cruiser right in front of you?
Yes, he's immediately in front of me there in the left lane.
And then Mr. Jarvis's vehicle, is he in the right lane?
He's the most visible vehicle in the right lane there, and the vehicle that he was following too close was immediately in front of him.
So now, are you able to see the two vehicles, one following the other very close?
Yes, you can see that, at this point, I've already observed the violation. I'm getting ready to initiate traffic stop.
Is that Trooper Martin
Yes, looks like he's already initiated traffic stop.
on the car ahead?
Yes. Just activated right there.
John X. Boy, 8053. John X. Boy, 8053.
Now, having watched that piece of video, is that a fair and accurate representation of what actually happened during that sequence there?
Yes, sir.
Was the video blurred a little bit because of the rain on the windshield and also the limitations of the video capturing device?
Yes, sir.
Did you then approach Mr. Jarvis's vehicle?
I did.
Did you encounter Mr. Jarvis personally at that time?
Yes, sir.
And was he driving the vehicle?
Yes, sir.
Were there any other people in the car?
Yes, sir. There were two other occupants.
At that time, when you made your initial contact with Mr. Jarvis, did you notice anything about his physical appearance that would indicate to you that he might be impaired for purposes of the FBI statute?
Yes, sir. His eyes were watery and bloodshot. And his speech was dilated. I had divided attention skills. He was mid-sentence and trailed off as he was retrieving the wallet. There's an odor of non-alcoholic beverage remaining from the vehicle was moderate strength.
Explain that about the divided attention.
So I asked him to retrieve his wallet, and he had indicated at one point that he was following the other vehicle from him home. And as he was retrieving his wallet, he said something to the effect of, I believe, I was following them home, but his inflection indicated he actually trailed off. That he was going to add more as he was retrieving his wallet, but didn't expand on that.
Did you ask Mr. Jarvis if he had anything to drink?
I did indicate he had, in his estimation, 4 beers, I believe it was.
Did he say where he had been, where he was drinking?
I don't remember if he did at the car. I think talking to him later, maybe at the car. I can't remember what he said. At the bar, Stonewall.
Now, at that time, based on what you saw as far as the driving, watery bloodshot eyes, dilated pupils, the divided attention issue that you spotted, smell of alcohol, and the admission to having about 4 beers, did that cause you to form a reasonable suspicion that Mr. Jarvis might be impaired on alcohol for purposes of the OBI statute?
Yes, sir.
Did you ask Mr. Jarvis out of the vehicle at that time, and did he comply?
Yes, he did. I did. He obliged.
They know you have a vehicle?
Yes.
99 Honda What's going on, man? How's it going? All right, here's the stuff that you flash up in front of you too close. Okay. You have your ID with you? Well, where's you guys out this morning?
I'm actually following them home. I'm taking these two to their
Oh, you
house.
know that truck?
Yeah.
Oh, okay, all right.
I'm taking them to their house.
That's the moment I was speaking about there. His inflection.
Yeah,
So I'm gonna be honest, I actually just bought this car.
Yes.
And so I don't have registration on it yet, or insurance. I do have the title though.
No problem. Do you have the old registration by chance? Previous owner?
Possibly. Alright, check, here's the title.
Is this your current address on your ID here?
Squire?
Yes.
Yes.
Do you go by Thomas?
Yes. Bill, I've already paid for it. I just haven't got everything switched over yet.
How much did you drink tonight?
I've had probably about 4 beers.
Okay. What was your, how long did you have your last one?
Probably about an hour ago.
Yeah. Okay. Thomas, what I asked you to do is ask us about the companies. If I see you, you're not doing anything, okay?
So much shit.
That's all
I
right.
have a shirt on my back. I don't have anything else on me.
At that time, once he was out of the car, were you anticipating perhaps administering standardized field sobriety tests?
Yes, sir.
Did you ask any preliminary questions leading up to that so that you would have an accurate understanding if he had any physical limitations or anything that might keep him from being able to accurately, or for you to be accurately administer those tests?
Yes, sir.
So what kind of questions did you ask him?
I asked a series of 4 standard questions. Do you wear contact lenses or glasses? Would you consider yourself in good physical health overall? Do you take any medications? And do you have any history of head injuries that cause you present-day issues?
Did he indicate anything that would cause you to believe that he wouldn't be able to perform the horizontal, or the standardized field sobriety tests?
No, sir.
Did you begin by administering the horizontal gaze nystagmus test?
After the pre-check, yes.
First of all, tell the court what horizontal gaze nystagmus is.
It's a form of nystagmus that we're looking for. It's indicative of impairment by a depressant, inhalant, or associated anesthetic, any of those 3 drug categories. Nystagmus in general, the involuntary jerking of the eyes.
And how is that used to determine if a person is impaired by alcohol or some other substance?
Per the manual, if, out of the 6 clues that we look for, the 6 validated clues, exhibiting at least 4 of those out of the 6 is indicative that this person has a likelihood of having a blood alcohol concentration of 0.080 or greater. So to observe 4 out of the 6 of those clues, like I said, it's 88% likelihood that he's impaired by one of the 3 drug categories that I mentioned.
So explain for the court what you have to do in order to observe those clues.
Sure. So we start with pre-check. Pre-check, I'm checking for equal pupil size, resting nystagmus, and that both eyes track equally. None of that is concerned. During the test, from there I'll move along to checking for lack of smooth pursuit, and I'll check for lack of smooth pursuit in both eyes. So to see that in both eyes, that's 2 clues, 1 clue for each eye. I did observe that for the first 2 clues out of the 2 that I checked for. Mr. Jarvis exhibited a lack of smooth pursuit in both eyes. From there, I'll check distinct and sustained nystagmus and maximum deviation. Distinct and sustained nystagmus. What I'm looking for there is I'm holding the stimulus that's provided out really as far as Mr. Jarvis can possibly look at it, still remain focused on it for at least 4 seconds, but no more than 30 seconds. And while it's being held out there, you'll see the eyes they're bouncing back to center if that clue is present. I did observe both, I observed that clue in both eyes, so out of 4 clues checked, at that point, that's 4 clues observed, so 4 out of 4. The final 2 clues I'm looking for is onset of nystagmus prior to 45-degree onset. From there, I'm moving the stimulus at a rate of 4 seconds from the nose, so 4 seconds from center out to 45 degrees. If nystagmus or the involuntary jerk in the eyes is observed during that point, that's 2 more clues if it's observed in both eyes. I did observe it in both eyes. So out of 6 clues that I checked for, I observed 6 clues.
Okay, so the stimulus is something like a pen.
That's what I use as the tip of the pen.
And you keep that 12 to 15 inches in front of Mr. Jarvis's face.
Yes,
You tell him to keep his head forward and don't move it follow the stimulus with his eyes and his eyes only.
Yes, sir.
Then you go through a series of different movements in order to see or not see that jerking movement that you described as horizontal gaze nystagmus.
Yes, sir.
And I'm going to show you what I've had marked as State's Exhibit 1 for identification and ask you what that document is.
This is page 1 of the impaired driver report that complete for the IRS. We call it the HP70B. That's just the Highway Patrol's number for this form.
And is that the form that is associated with Mr. Jarvis's case?
Yes, sir.
And did you record a record of what you observed on the horizontal gaze nystagmus test that you performed that evening?
Yes, I did.
What does that form show?
It shows that I observed, out of the 6 clues that I checked for, 6 clues having been observed.
6 of 6 clues. And I want to make sure that the court understands that, are you trained to perform this and the other field sobriety tests, the standardized tests as they're set forth by the National Highway Traffic Safety Administration and approved by the state of Ohio?
Yes, sir.
And that's part of your training as a state trooper?
Yes, sir. I'm current, up to date on the latest manual as well from this year.
And did you administer that horizontal gaze nystagmus test in compliance, substantial compliance with those standards?
Yes, sir.
According to the National Highway Traffic Safety Administration and the manuals that they promulgate in order to train state troopers such as yourself, what is the likelihood of a person having a breath test score over 0.08 if they have at least 4 of 6 clues on the horizontal gaze nystagmus test?
88%.
Yeah, Jerry, you want to say something about it? I said, walking back with you. Just stand right there in front of my. Come on, I'm gonna get these flashing lights out of your face, okay? Where are you guys drinking at tonight? We were at 7. Oh, okay. All right, gotcha. Oh. I gotta stop a lot of people coming out here. I didn't realize it was still like, really popular place.
And so normally people roll out, right?
Gotcha. Oh, really? So it's pretty much like.
Yeah, as soon as that's when people roll out.
Yeah. Okay. Do you know my son's phone? Okay, perfect. Just to make sure I was finding you on people. When you stand right there for me.
Okay.
Perfect. And turn facing me.
Okay.
And then feet together like mine are, toes to. Perfect. And hands down your side. You have contacts, relax it. You take the medications. You can see yourself and your physical.
Yes.
And then you can get your head injuries.
So I did have a brain injury from a car accident, but I was like 8 years old, so it's been quite some time.
Any lingering effects from that?
Not necessarily.
Okay. When was the last time, the reason I asked you people, when was the last time you smoked a weed?
I can't, yeah, I'm a union carpenter, so I actually that's not.
Yeah, all right, good deal, man. So Thomas, why don't I ask you to just stand here and touch this?
Trooper, what I would like for you to do while this is playing, I'd like for you to tell the court which part of the horizontal gaze nystagmus test you were performing as it goes along.
Yes, sir.
Well, all right, girls, all right.
Oh, that's your yes, right. What's this? Yep. Okay. Yep.
This is the pre-check right now.
What are you looking for there?
Equal pupil sizing, tracking, and resting status. Now I'm moving in and checking for lack of smooth pursuit.
Now, what are you doing?
Distinctness, sustained status, maximum deviation. Checking child placement. This will be onset of status prior to 45 years.
either one.
So to summarize, you saw 6 of 6 clues of horizontal gazing status.
Yes, sir.
Did you administer the walk and turn test after that?
I did.
I would like for you to explain to the court what the walk and turn test is, how it's supposed to be performed, what clues you're looking for.
So the divided attention test essentially is what we're looking for there. It starts with having somebody stand in a starting position where offers, if there's not a safe and suitable line available, in this case there wasn't, we're on the highway, I would ask somebody to use a fall line. It was whizzing by at least 55 miles an hour through there. So in this case, I'll ask him to imagine a straight line and a position on my vehicle. And it's, preferably the front license plate, but I'll use other points on my vehicle if it's more suitable. While they're in a starting position, I'll have them stand with their right foot in front of left, standing toe to toe with their hands down their side. I'll give them the instructions.
Now, can you tell them not to move until you...
I'll say stay like that until I said begin, you understand? And then during the instruction phase, before the test has begun, there's 2 clues that can be observed. They start the test too soon, or they move their feet for balance. I did not observe either of those. There's 8 total we're looking for the entirety of the test. The instructions given essentially are take 9 relative steps along the line you imagine. Turn yourself around, take another 9 relative steps back. While you do that, make sure you keep your hands down your side. Look down at your toe. Count your steps out loud, and you don't stop till you complete the instructions. So during the test, there's 6 other clues that we're looking for. Out of 8 clues total that can be observed during the test, I observed 2. For this male, observing at least 2 out of the 8 or more, there's a 79% likelihood that this person has an EAC of 0.080 or greater.
And did you record those, I'm referring back to Exhibit 1, did you record those on the paragraph report?
I did, under the walk and turn test, I checked it. He stopped while walking, he did not touch on toe. That doesn't mean every step is going to, or they stop after every step. It just means that it was a piece of observed once during the test.
Did you administer the one-leg stand test?
I did.
Finish doing the walk and turn first.
I'm sorry, I think it's something doing that, just in case, I know, once we get this on, we'll see if we get one street being, questions, let me know. You just stand right there, and then just maybe take a step to the right there. Perfect. What I'm asking you to do at this point, Thomas, just imagine a straight line off from you to that number 4. From that part of the animal line. Are you able to imagine that line off from you to that 4 animal line? Perfect. Well, I ask you just take the left foot on that line you imagine, and take your right foot, put it in front of your left, and touching the toe. Keep your hands down on your side. Say like that, I told you at the beginning, you understand? Yes, sir. We're going to ask you, Thomas, to take a series of 9 toe-to-toe steps along that line you imagine. Yes, sir. Turn yourself around and take another 9 toe-to-toe steps back. You understand so far? I'm going to demonstrate for you, okay? It's going to look like this. You're going to be in the starting position, your hand. It's going to look like this. 1, 2, 3. You got to take 3 toe-to-toe steps. You'll take 9. On that 9th step, keep your front foot touching the ground. Use your other foot to turn yourself around. A series of small steps like I'm doing. As you turn yourself around, take another 9 back. 1, 2, 3. Again, I took 3 toe-to-toe steps. You'll take 9. As you do this,
Back foot's going to be the one that I turn on.
use your other foot. So you use your front foot to front foot stays on the ground and on that line you're imagining it. And then that other foot will turn yourself around and series of small steps. As you do this, just make sure you keep your hands out of your side. Look down at your feet and count your steps out loud. And you don't stop till you complete the instructions. Any question about what I asked you to do?
So 9 forward, turn around, front foot.
9 toe steps. And then again, as you do this, hands on your side, and down your toes. Count your steps out loud and don't stop until you complete the instructions. That makes sense? Yes, sir. All right. You understand the instructions? How much you make again? Down your toes there. Next thing I'll ask you, you can turn around and face the good.
All right, now, did you then administer the one-leg stand test?
Yes, sir.
And I would like for you to explain to the court what the one-leg stand test is.
Again, it starts in the instruction phase, so I'll have them stand a certain way. And then from there, what I'll do, while they're standing a certain way, again, they're standing their feet together, hands down on their side, don't move that forward, you understand, that's the way that starts. From that point, I will have them with instructions, so I'll demonstrate it for them as well. What I'm asking you to do, take a foot of your choice, any one, doesn't matter to me, take that foot of your choice, hold it approximately 6 inches above the ground, parallel with the ground, always going to say like mine is, so that you can reference how I'm standing at the time. And raise down your side, look down your toe, count a series of 1,000s, like so, 1,001, 1,002, 1,003, 1,004, and so on, until it says stop. And then that'll go for 30 seconds. I'll time it on my watch. There's 4 clues that you can see at that point. 2 out of 4 is 83% likelihood that person has an EAC 0.080 or greater odds or 1 for the one stand test.
All right, well, I'm going to okay, I'll take it.
Stand with your feet together, should work earlier, and hands on each other, stay like that, till 7 again, you understand? All right, what I'm asking you to do is I want you to take a foot of your choice, left or right one. It doesn't matter, when you take that foot of your choice, hold approximately 6 inches above the ground, parallel with the ground like mine is. Left leg's nice and straight, no better than you. Keep your hands down to your side, look down at your toe. Count a series of 1,000 like so, 1,001, 1,002, 1,003, 1,004, and so on until it says stop. Does that make sense? Any questions for me? That's right. If you understand instructions, give me 1 second here. If you understand instructions, you may begin. I'll hire there, go down your toe. Alright, you stop. Last thing I'm asking you to do is Thomas.
Now, did you record the results of the one-leg stand on the impaired driver?
Yes, sir.
And you say that he had 1 clue?
Yes, sir. This way.
Is this a fair, accurate representation of the form? Is there anything different about this than what was submitted originally?
No, sir.
I want to ask the state's exhibit 1 to be amended.
All right, any objection? Mr. Jarvis?
No, sir.
You admitted.
After finishing the one-leg stand test, did you have any further conversation with him about how many beers he had had to drink?
I don't recall.
And then you, at this point, you arrested Mr. Jarvis for OVI?
Yes, sir.
I'll take a nice deep breath and blow for me. Okay. 1 second there. Alright, I'm asking you to take a nice deep breath and blow. And stop. You walk right over to me. So you said you had your last name, how long ago? About an hour ago, sir. Okay. And you had how many total?
Probably about 4 or 5 years, yeah.
Okay. You're 113, you are living. James, why are you back? You're under arrest for operating a vehicle while here. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to the lawyer for advice. Before we ask you any questions, ask the lawyer present to any questions. Dealing with paperwork, will be appointed for you prior to any question, if you so desire. If you wish to answer your question now without a lawyer present, you have the right to stop answering your question at any time. You also have the right to stop answering at any time until you talk to the lawyer. You understand your rights? Okay. I'm going to go ahead and fill you on this. Just because you're under arrest doesn't mean you're going to jail. It's 2 different things. With that in mind, I do have to ask a couple questions so I can give you a better answer.
Mr. Jarvis a breath test?
An official one at the post?
Yes.
Yes, yes, sir.
Before you, as part of your offering of a breath test to someone such as Mr. Jarvis, do you read him certain advisals, I guess they're called, in Form 2255?
Yes, the B&B's 2255 form. There's an entire section you have to read through them on the back. And then I'll always ask them if I have a question about it. Go from there.
And basically, it's the consequences of taking or not taking the breath test.
Yes, sir.
Is that the form from Mr. Jarvis's case?
Yes, sir.
And did he sign that acknowledging that he understood?
Yes, sir.
I'm going to ask that Exhibit 2 be amended.
Any objection?
No, sir.
So did you take him back to the post and administer a breath test?
Yes, sir. Breath alcohol concentration was 0.124 grams per 210 liters.
That's over the legal limit of 0.08?
Yes, sir.
Now, you indicated in the citation that Mr. Jarvis had a previous OBI in 2022.
Yes. I don't remember details off the top of my head. I want to say it was maybe out of a different state, Kentucky. Maybe.
First thing I want to do, though, is it's going to be out of order. I'll show you what I've had marked as State's Exhibit 4 and ask you what this form is.
This is his results page that prints from the intoxilizer breath test. The machine that we utilize at the post, this just has his official breath test. Didn't register it. Breath alcohol concentration, 124 grams per 210 liters.
Were you the officer who administered that test?
Yes, sir. Other things to note that it has the time versus observed, so the time, that I came into contact, which was 3:43 a.m., and then the time of the test was 4:20 a.m., so less than an hour later.
Anything indicated on there that there was an error or some sort of malfunction in the machine?
No, sir.
And I'm going to ask the State's Exhibit 4 to be amended.
Any objection?
No, sir.
Any amendment?
Now, I've marked this as State's Exhibit 3 for identification and ask you to look that over and identify that.
This is Mr. Jarvis's legal documentation and record. He has his driver's license here through the state of West Virginia. Here is, oh, no, I was mistaken. So the past OBI was not through another state, it was through the state of Ohio, dated 2/23 of 22. That was an OBI conviction. Appears to be a alcohol concentration of 0.16.
And what court was that at? Can you tell?
Lawrence Municipal, this one.
So is that the information you used when you cited him on the citation saying that he had prior in 2022?
Yes, sir. The paper that I'm actually looking at here, I believe is what's generated by the state when somebody who doesn't have a license through the state has an OBI conviction, because what that does, it helps them track the suspension, is my understanding of it. So I believe that's what this form is here, that shows his prior conviction.
I'm going to ask that Exhibit 3 be amended.
Any objection?
No, sir.
Any amendment?
Did you cite Mr. Jarvis with an OVI being a second offense and also for following too close.
Yes, sir.
Your Honor, if I can have that exhibit back, please. I'd like for you to look back here at the February 22 conviction. I'd like for you to look at and tell the court what else he was convicted of at the same time.
Following too close.
So that's the same as this case.
Yes, sir, exact same charge.
That's all I have, Your Honor.
All right, Mr. Jarvis, you can ask this witness questions if you wish to. Do you have any questions you want to ask?
No, sir.
May you sit down?
Thank you, sir.
And we rest, Your Honor.
Mr. Jarvis, do you have any testimony that you wish to offer by a witness or yourself?
No, sir.
We do also want to introduce the video as Exhibit 5.
All right, it'll be considered marked. And it'll be marked as Exhibit 5 and admitted into evidence. Can you pull up, apparently he's got an older file here, can you pull that up? Yeah, it's 22. You show me the history. That was completed August of 2022. But he did everything. Yeah, it looks like he did everything on that file. Okay, I'm going to make a finding of guilty on this case based on the evidence. So, no reason not to proceed to sentencing. What's the state's position on sentencing?
Well, Your Honor, it's a second offense. We don't have any objection to the mandatory minimum of 10 days in jail. And if he were to convince the court to make it 5 days in jail and electronic monitoring, we would not oppose to it. We wouldn't be opposed to it.
All right, Mr. Jarvis, anything you want to say before sentencing?
I do have a question about the monitoring, just in case it does end up going that way. How does that work? Because I've never dealt with it, don't understand it. Do I have to schedule?
You would have to wear like home monitoring, and you would be allowed to. Are you employed, sir?
Yes.
You are. Where do you work?
So I do bridge work, and I'm working in 2 different places at the moment, Point Pleasant and Leetart, West Virginia. Both are, it's about an hour and 15 minutes away from Barboursville. And I didn't know how how that would work, or if I would just have to take off work to be able to do that.
Well, I haven't decided to let you do that at this point.
I understand. I was just asking. I was curious.
Anything else that you want to tell me?
Not necessarily. I'm not asking for pity, sir. I'm just asking for mercy here. I really don't want to lose my job. It's about the only thing that I've got right now. I would like to be able to stay working as much as I can so I can afford to pay for this, considering I wasn't able to afford to pay for an attorney. I tried to get as much money as I could together and just wasn't able to get the down payment or the upfront payment that they were asking for, so.
And a matter of curiosity, how much was that?
I'm sorry?
How much were you quoted?
The few that I called and talked to were normally around $2,500. They were wanting up front and then another $2,500 after the first trial.
Okay. All right, anything else you want to tell me?
No, sir.
Okay, I'm going to impose a $1,000 fine because it's the second offense. I'll order you to pay the court costs. There will be a 1-year license suspension, which I will start the day of the offense. I'll sentence you to 30 days in jail, and I'll suspend 20. 2 years of level 4 probation. He's going to start jail today. 60 hours of community service.
How many hours?
60 hours of community service. It's mandatory that you seek and obtain substance use counseling on a second offense. I'm assuming with your work you have some sort of health insurance?
I do, but there's an issue with it right now. For some reason, it's not active.
Okay. Well, you'll have to figure that out. There's a lot of, as of now, there's a lot of agencies that will offer that kind of counseling to you. Perversely, it's harder to get if you got insurance, but
so I had actually
it doesn't matter. You still have to do it. So if you have to pay out of your pocket, you got to pay out of pocket to get these substance use counseling, and that's mandatory under Ohio law.
I do have a question.
Yes, sir.
Is that able to be done through Prestera? Because I did actually go down there a couple weeks ago to try to get an appointment, and they were supposed to call me back. And
You're listed as a West Virginia resident?
Yes, sir.
I mean, I don't have a problem with Prestera doing this, as long as it's a qualified substance use counseling program.
Okay.
You can do it there. Okay, I'm going to set a review hearing for you for January. And I'll make it the 26th, January 26th. Will be your first review hearing. And that'll be at 9 o'clock. He's commanded in the hands of the sheriff.
What about the legal aid, Your Honor, following too close?
$10 fine on following too close.
State of Ohio recalls Jade Lewis, case number CRA 23-432A and B, CRB 23-433A and B.
Okay, we took a break to let Ms. Lewis talk with some counselors about treatment, come up with a plan. Do we have such a plan?
I believe, Judge, if you don't mind, I'd declare consult Megan.
Your Honor, we did speak, she did an assessment with both me and Connie with Bethesda. She has agreed to go to Bethesda. She's gonna go today, and she also signed paperwork to join deflection.
Okay, so that's really important. So you're going to be responsible to the QRT to let them monitor you. But if you're successful, the good news is you can get that, the most serious charge can be dismissed if you're successful. And you get treatment too, so you don't get a felony on your record.
Yeah.
But this is serious business and you got to take it serious. And do
Yeah, I know.
You can't play around with it. Okay, so I'll order her to Bethesda and QRT. So because of that, I don't think we need to come back as often, maybe a month out. Make it November 27th. But they'll let me know if there's a problem, which means you can be brought back into court earlier if you have a problem with QRT. If you don't do what they tell you to do, you'll be coming back to court earlier than November 27th. Okay, good luck. This is a really good opportunity for you to get clean, take advantage of it, do what you're supposed to do, come back with your reports.
Okay.
Let them know be there right now. Please.
Okay. November 27th. So next time.
Thank you,
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus James C. Jones, case number TRC 23536.
Hamid's case is set for a motion, but I understand we're not going to have a motion.
That's correct, Your Honor. Mr. Hill and I discussed based upon the possibility that, and what I would have thought would have been a likelihood that I was going to end up being sick today, calling it off. I've spoken with a potential resolution with Mr. Jones that Mr. Hill made today, Your Honor, and after speaking with him, I don't think that that resolution he's going to be agreeable to that. So if we could reschedule the matter for evidence.
Okay.
And so the court's aware as well. I filed a supplemental motion on Tuesday that removed some of the issues that otherwise would have been contested based upon the state providing that information. There was nothing added to the motion, but there were a few things removed based upon that.
One thing too, Your Honor, is that our trooper, I'll have to make sure that, when we set the date that.
Well, if you just file a motion to continue.
As long, like I've always taken the position, Your Honor, that as long as it's not the day of,
right,
I have no objection to it. So I'm confident if there's a problem, Mr. Hill will get it to me, and I'll agree to the continued date.
Well, the 6th could work. The 9th could work. The 13th possibly. 17th is out. Any of those dates work?
I'm in trials at other places all of those days, Your Honor.
Okay.
20th.
20th could work.
I'm available the 20th.
Okay. Set it for noon. Is that best?
That would be fine, Your Honor.
Motion hearing November 20th at noon. But it's good if the client can be available before then in case something comes up where you can talk. If you just show up right at noon, then it may take longer to get things started or resolved. So November 20th, noon for the evidentiary hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Cody J. Mead, case number TRC 23154 A, B, and C, TRC 221690, A and B, TRD 222101, A and B. Cody Mead. Yes. Cody.
Well, Mr. Mead, any reason you shouldn't go to jail because you have done not much?
Your Honor, I jail 6 months on 9/11, and poor child, same day. I've been getting back and forth to ride, I ain't been driving, I haven't, I've trying to make progress with it as far as, trying not to break any laws, but I'm trying to slowly dig out a hole that I put myself into, and, the last review here, he said to get some fines paid, put some money on some fines, and, I didn't hear you mention, about doing community service. Or not community service, but a cleanup day, or something like that. It's just been struggling trying to get, since I was been out, trying to get late, catch up, and have to move from one place, getting moved to another. If it was mentioned, I do apologize. I know, I didn't mean to just like not put in my show. I just didn't have a lot going on, trying to maintain sobriety, trying to maintain myself, trying to maintain the family with five others.
Okay, I'm gonna find you in contempt for not coming to community service or doing anything. You haven't done anything, really, on your case. I'll sentence you to a day in jail. So I was thinking 2 days, I'm gonna give you 1 day. So you can get out. You've been in custody since about 9:30 this morning. He can be released 9:30 tomorrow morning. So that's just a shot across the bow. You gotta take this stuff seriously. I know you got a lot of stuff going on. You say you got 5 kids?
I got 4.
4.
And a wife.
Okay, well, that's a lot of responsibility.
It is, sir.
But I'm going to take it that those kids and your wife weren't with you February 11th, 2023 when you were out at 3:41 a.m. and got your last OVI.
Yes, sir.
So,
I haven't driven my kids in the car since they were born. I've been stuck in addiction. I don't want to get pulled over and
so
CPS.
stop don't make excuses. Your kids are not an excuse. I mean, people can go party when they want to go party when they got kids, but when they got to go to jail, all the kids, well, the kids aren't going to be an excuse.
I don't. It's not.
That's enough. You're just digging the hole deeper. You want to dig the second day back on? I don't want to hear your excuses. Do you hear me, man? Be a man. Own up. Do what you're supposed to do. Don't throw your kids in front of me as an excuse. You got it? I'll see you November 27th is your next hearing, 9 o'clock. I think that finishes this.
Yes, sir.
Court's adjourned.
Missy wants to know she's doing that Christopher Road camp, special prosecutor paper you can sign every day.
Okay.
She wants to know what is everything she has put on there. Why we got a special prosecutor.
There's a conflict. Victim is